right, good morning, counsel. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Ullman, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. All right, counsel, we have just a few matters to dispose of before we reach our opening statement stage. Counsel, yesterday the jurors, when they retired, one of the jurors handed the bailiffs a note for the court, and they were just curious as to whether or not the court was going to allow them to watch the Super Bowl this weekend, and I've indicated to them that yes, they can, and that we would arrange their visitation schedule accordingly. So I take it there's no comment on that. All right, Mrs. Robertson, would you create a file for juror notes, please? All right, first issue to be resolved is the defense motion to allow Mr. Simpson to briefly address the jury during the course of defense counsel's opening statements. All right. Certainly.
Your Honor, the first objection interposed by the people is that this has never been done before. And we have located at least two California precedents where it has been done before. The first came in probably the first case of the century, which was the trial of Clarence Darrow here in Los Angeles for jury bribery. Even though Mr. Darrow was represented by eminent counsel Earl Rogers, he was allowed to directly participate in the presentation of the opening statement and closing argument to the jury. The second example came in 1972 in the trial of Angela Davis in Northern California, in which, although she was represented by counsel, she also was allowed to present opening remarks to the jury. So it's not a question of proposing something that has never been done before, as to which there is no precedent. The second objection raised by the people is that they will be deprived of their right of cross-examination. And I think that really misconceives what is being proposed here. First of all, Mr. Simpson will not be testifying, and the standard instruction given to the jury with respect to all of counsel's opening statements, that they are not evidence and not to be considered as evidence by the jury, will certainly apply as well to Mr. Simpson's opening remarks. But what is being proposed really is not a presentation in the traditional form of an opening statement. What we are simply proposing is that Mr. Simpson be allowed to introduce himself to the jurors, to introduce the defense team, the lawyers who are representing him, and to simply reiterate his plea of not guilty. Now, of course, the prosecution has no opportunity to cross-examine a plea, and we believe it would be quite appropriate for the jury to hear the plea of not guilty that sets this trial in motion directly from the lips of the defendant. This is not really all that remarkable a request. What it really seeks to do is to focus the attention of the jury back where it belongs in the midst of all of this hoopla, and that is on the defendant who is on trial, to remind them that what's really at stake in this trial is one man's freedom. We want them to see who that man is. We want them to hear from him very briefly in terms of introducing himself, introducing counsel, and reiterating his plea. The second part of the motion simply addresses a physical demonstration that is routinely done in trials, routinely done by the prosecution as well as the defense, and again would not involve any testimony but simply a preview of evidence that will be presented in the course of the trial.
All right, Mr. Allman, it was represented to me that preview would be merely of the defendant's knees regarding certain surgeries that he has undergone as a result of his athletic career. Is that correct?
Yes, that is correct.
All right. And have you contemplated the security desires of the sheriff's department that they have their bailiff within close proximity of Mr. Simpson at the time that this is done, and how you would do that in a manner that would not convey a unnecessarily negative message to the jury?
Well, that was the reason we brought this up in advance, Your Honor, so that adequate preparation could be made to post a deputy on this side of the courtroom if that's necessary, but it simply involves him walking from one side of the courtroom to the other.
All right, and unfortunately, the logical place to do that is right by prosecution counsel there.
Mm-hmm.
So we have that proximity problem as well. Have you contemplated the logistics of our unfortunately small courtroom?
Well, if the prosecution wants to just switch sides with us, we'll be glad to move over to this side of the courtroom. But
You've asked for that already.
I don't think that they have any concerns about being in proximity of the defendant.
Well, I have concerns about that as a security concern is all. All right. Thank you, counsel.
Sure. Could we have just a moment? Mr. Cochran has discussed the issue with the bailiff, and there's no problem with the bailiff being in proximity while Mr. Simpson addresses a jury or displays his need.
All right. I'll hear from the people.
Thank you, and good morning, Your Honor.
Morning.
First of all, this is not an opening that counsel proposes. It's simply an attempt to capitalize on whatever defendant's star appeal currently is with the jury, and to get him to have close proximity with them to impress them. What is the probative value of a scar? What does it prove to this jury in terms of his physical capabilities on the night of June the 12th, 1994? It proves nothing. In fact, we all know that on the morning of June the 12th, he was playing golf. We also know that within weeks before the murder, he made an exercise video. So the probative value of that scar is nil, and the misleading nature of presenting that scar to the jury is great. The inference that the defense will seek to draw from that scar is that he was incapable of certain physical acts. If that is what they intend to present, that's fine. Let them present testimony that is capable of cross-examination. But to have the defendant essentially testify before the jury without taking the witness stand and being cross-examined is inappropriate. The cases in which the defendants have been able to address the jury in opening statement in previous occasions have been cases where the defendant was acting in pro per. This defendant is not in pro per. He is represented by many attorneys. If he desires to testify before this jury, then let him do so as all witnesses do, on the witness stand, and be subject to full and complete cross-examination. Case law is completely in favor of the people's position in this regard. People v. Perez, 216 Calap 3rd, 1346, in which the defendant requested to be allowed to exhibit his tattoos without being sworn or giving testimony. The court refused his request and ruled that the exhibition of the tattoo would be testimonial if offered, to impeach the testimony of an undercover officer, and essentially that's what the injuries now being proposed to be displayed to the jury is being offered to show, that he could not, in fact, commit certain acts that he is charged with committing. It's testimonial in nature. Let's make no mistake about that. What is the purpose otherwise of demonstrating the scar or of talking about or showing the jury what he can and cannot do? It's going to give him the ability to limp up to the jury box, get close to the jury, and try and impress them with his physical presence. That there's nothing appropriate and there's no legal benefit to this in terms of what is appropriate in a court of law. If the defendant would like to testify, that's fine. But to do this and then shield himself from cross-examination, say, don't ask me any questions. I just want to get up there and show you something. I want you to draw inferences from this. I want you to take evidence from this without being subject to cross-examination is entirely inappropriate. The people would not be entitled to do that because there would have to be a foundation laid. People versus Perez makes that very clear. It indicated that it would be irrelevant as demonstrative evidence as well, which is what the defense claims it's proposing here. Although the people dispute that, and really it's a testimonial in nature kind of thing they're proposing. Nevertheless, even if it's demonstrative, the court in Perez ruled that because the defendant had laid no foundation for the admission of the evidence, it was appropriately denied. In this case as well, what the defendant proposes to do requires either his presence on the witness stand or some testimony from the witness stand to lay a foundation for its admission. To simply display something to the jury without any evidentiary basis gives them nothing reliable and nothing of probative value. It is only a blatant attempt to impress the jury with his charisma and star appeal. That is not an appropriate vehicle in the opening statement. Let me indicate also that the case of People versus Wong held similarly. People versus Wong, the trial court indicated that it was improper to have the defendant exhibit his arms to the jury without first being sworn as a witness. In that case, 35 Calap 3rd 812. The defendant in that case wanted to indicate that he was not an addict. He had no track marks on his arms. The trial court refused to allow him to do so unless he subjected himself to cross-examination. On appeal, the court was upheld, and it was determined that if it was a testimonial if it was being offered as testimonial evidence, it was properly refused when the defendant declined to be sworn as a witness and subject himself to cross-examination. It also ruled that if the offer was a demonstrative one, then the trial court was justified in rejecting it on the basis that it was irrelevant. As I've indicated to the court yesterday, his arm was being offered on May 12th, 1971, to show the condition of his arm on June 5th, 1970. The defendant's condition today, or the existence of that scar, without laying a foundation as to what the significance of that scar is and how it impacted on his physical capabilities, is something that exists without foundation. It has no probative value in and of itself. If the defense wants to do it as part of an opening statement, they're going to have to also proffer something that lends it some value in terms of probative value. What I mean by that is they can offer a photograph of the defendant's knee, but simply holding a photograph up isn't going to get them very much, shouldn't. But the defendant, in terms of its evidentiary weight, because what does that mean in terms of his physical capabilities? Or his limitations. Having the defendant as well get up to tell the jury that he's not guilty is another blatant attempt to have the defendant address the jury without being cross-examined. It's like issuing a blanket denial and then saying, you can't ask me any questions. In a court of law, Your Honor, when a defendant seeks to testify and issues a blanket denial, that opens the doors to cross-examination as wide as they can go. And the people are permitted very far and wide-ranging cross-examination. The defendant seeks to do that in this case and preclude all cross-examination. He seeks to protest his innocence and yet not allow anyone to ask him any questions. That is entirely inappropriate. The court, I'm sure, is very well aware of that. If he were in pro per, he could get up and say whatever he wanted to. He's not.
All right, what's your page cite on People versus Wong?
835.
What's your page cite on Perez?
And on it's 1348 and goes on to 1349. The holding, 1348 and 9 give the factual exposition, 1350 gives the ruling.
All right, any other comment?
Yeah.
Thank you. Mr. Ullman?
The suggestion that a plea of not guilty subjects a defendant to cross-examination is simply not the law. The plea of not guilty is what sets this trial in motion and puts the burden on the people of proving guilt beyond a reasonable doubt. It's really incredible to suggest that somehow the jurors will be prejudiced by actually hearing the plea of not guilty from the mouth of the defendant himself. Actually, the only person who can enter the plea is the defendant himself, and that plea is what sets these proceedings in motion. And we believe it is quite appropriate and does not open up any doors to cross-examination, simply to have the jury observe the defendant and hear his plea of not guilty from his own lips. The suggestion that this is some sort of ploy to capitalize on the defendant's charisma or celebrity status, it's just the opposite. It is just the opposite. We do not want this jury to view the defendant in terms of a celebrity. We want them to view him as a human being. And that suggests the greater need in this case to do it, because there is just so much starstruck quality about this whole proceeding, and we think it would be very healthy to remind everyone, especially the jury, that what's at stake here is simply the liberty of a man, a human being, and here he is, OJ Simpson. In terms of the lack of foundation for the physical capability of the defendant, that will be presented in the course of testimony. Obviously, the opening statement doesn't present all of the evidence. It's a preview of what is to come, and this is an important part of the evidence that we would like to preview for the jury. When it is presented in the course of trial, there will be foundational testimony from Mr. Simpson's physician as to his physical capability to corroborate the physical demonstration.
Well, when you say demonstration, now you got me scared. Is this an exhibition? Exhibition or a demonstration?
Exhibition.
Two different things.
Right.
Okay. Thank you, counsel.
Thank you.
All right, I've reviewed the cases cited by the people, and the only cases that I could find that were of interest were a case out of New York and a case out of the Supreme Court of Mississippi that dealt specifically with the request of a represented client to address directly a jury. The motion to allow the defendant to directly address the jury will be denied. The motion to allow him to exhibit to the jury his knee injuries or the result of the scarring and the surgeries will be allowed. All right, counsel, we need to resolve then the last remaining issues on the exhibits, and we'll be prepared to go forward with opening statements. Mr. Douglas.
Thank you, Your Honor. Good morning. Yesterday evening, Your Honor, we were attempting... One moment, Your Honor. Yesterday evening, Your Honor, we were discussing the possibility of making alterations to the SOC timeline chart, of which there was an objection. As the court will see, we have altered the offending language to reflect the details and circumstances of a report that was part of an analyzed evidence report that I'd like to submit to the court and which I have already given to opposing counsel. What it says basically, Your Honor, is that there is a notation referring to different pieces of evidence. There is a notation for socks, navy blue/black. There
Is
is,
the June 29th report?
this is a report, Your Honor, if I may approach?
No, just answer my question. Is it the June 29th report?
Yes, it is. And it talks about there being, quote, dress socks, semicolon, blood search, paren, none obvious, close paren. And we would submit, Your Honor, that this is in fact a fair reflection of what we think the evidence is going to show. We would submit that that chart is not unduly prejudicial, and we would submit that the court should overrule the objections and allow the admittance of that chart.
Who was the author of that report?
This refers, Your Honor, this document apparently was prepared for the split hearing. Peoples 2 is the split hearing. And Yamauchi, Kessler, and Matheson each testified about the process by which they took out different pieces of evidence and examined it. And this was a document that was prepared specifically for that hearing.
All right, that doesn't answer my question.
Who prepared the report?
Who prepared that report?
Michelle Kessler, Greg Matheson, and Colin Yamauchi.
Was that the index that was prepared, the evidence index?
It says summary of analyzed evidence by analysis performed. That's the title.
Okay.
It's Exhibit 2 at the split hearing. The remaining objection, Your Honor, would be in response to the concerns about the videotapes and the scenes that were reflected of different officers walking through the crime scene at various times. We have now obtained the remaining tape recordings, and Your Honor, there was a misstatement yesterday. The scenes that were shown in the tape that has been given over to the people are not scenes that were taken from CNN, but rather they are a collection of different takes that were received from different local news media, so that for us to introduce these different snippets, if you will, at trial, we will simply be able to lay the foundation by subpoenaing and bringing in to testify those operators of, I think it's local channels 5, 7, 11, and 13, from whom these particular snippets were culled. That tape has now been provided to the court, and that tape has also been provided to the people. We now have the tape from San Francisco that had 2 other blips that were not shown on the first tape. I am told by Mr. Hodgman that the people would continue to maintain their objection. So what I propose, Your Honor, is that the court allow the showing of the scenes that were displayed yesterday. They are scenes, Your Honor, that are very capable of being authenticated. In many ways, it is self-authenticating. In many ways, they are authenticated because there will be an evidence or a police log where each individual who comes onto the scene first checks in with one of the police officers that are there. That log will be an item of evidence, and it is possible by showing the scenes and having those depicted there testify to establish clearly when the various pieces of scenes were taken and what sorts of things were occurring. It is true, Your Honor, that it is the people's crime scene. It is true, Your Honor, that they themselves do not have a videotape of the crime scene. There are certain discrete acts that are going on. For example, Detective Lang measuring a certain location. For example, you see criminalist Fung placing down particular evidence tags. You'll see detectives walking through, Detective Van Adder and Rogers walking through, and quite clearly the sheet is there because the body has been removed, but the sheet remains, and it shows, Your Honor, the sort of sense that we are going to depict in words. It helps to provide a visual context to the words that Mr. Cochran is going to speak. He is going to discuss how the evidence will show that there was contamination of the crime scene. We would then hope to show pictures that demonstrate, that reflect the contamination of the crime scene. They are going to offer evidence, I suppose, Your Honor, how the crime scene was not contaminated. Perhaps they'll show that when these scenes were shown, all of the items of evidence had been collected. Perhaps they'll show or they'll offer evidence that when these scenes were shown, it was the next day or the third day after. That is the risk that we are going to take by the statements that we are going to make in our opening statement. But whether or not there are the visual reflections of certain words, Mr. Cochran, I think quite properly, will be able to discuss and to speak about how the crime scene was contaminated and how we contend these scenes are simply a small reflection from the only live record that is available showing the conduct of Detectives Van Adder and other detectives at both the Rockingham and Bundy crime scenes on June the 13th. Your Honor, that I think is the end of my objections to the charts that the people are going to offer and my explanation to the items that were remaining yesterday.
Thank you, Mr. Douglas. Ms. Clark? I'm sorry, excuse me, hold on a second. All right, Ms. Clark?
I thought that the court had concluded its ruling yesterday with respect to the tape. Mr. Cochran made a motion that when a ruling is issued, we not re-argue it, and we all agreed to that.
But what I said yesterday is that if the defense makes the videotape available to you, and after reviewing the tape, you still maintain, I mean, who knows, after looking at it, you might have changed your mind. Now that you've had the opportunity, it's been brought here, what's your position?
We haven't had a chance to see it. They just gave it to us this morning when we walked into court.
How long are these videotapes, Mr. Douglas?
Your Honor, the first tape was played, I think, in its entirety yesterday.
Correct.
The second tape, which is we got this morning from San Francisco, is approximately 25 to 30 minutes long. However, a lot of that is a press conference by police officers. The first 5 or 10 minutes contains the 3 clips that we wish to use in opening today.
The first five or 10 minutes of
Yes.
this?
In addition to the ones that we showed yesterday.
The same problem exists now as it did before. We don't have a foundation as to time, and time is very important. The bloodstains were collected at a certain point, and that's not established with the tape. Secondly, there's a counter at the bottom of that tape that's very misleading because it looks like all of these different actually pieces of tape were one continuous shoot, which is not the case, as counsel even concedes. There was considerable editing done to that tape, and the people maintain their objection.
All right, don't you think we ought to at least look at the first 5 or 10 minutes to see if you still do?
I will, certainly, Your Honor.
All right.
I'll be glad to. Let me go on to the other exhibit. With respect to the SOC timeline,
Yes.
what Mr. Douglas has represented to this court is very misleading. And I confronted him this morning, and I explained to him that on this is not a business record, I should indicate to the court, first of all. It was a chart prepared specifically for the Griffin hearing and the blood split hearing, actually, at my request, because I wanted to see exactly what they planned to do with all the items of evidence and what seemed to be sufficient for a split, what did not, what was capable of PCR, what seemed to be capable of RFLP. In the box marked comments, it shows blood search because that is what they planned to do. It had not yet been done. These are navy blue to black socks, which if you look at it with the naked eye, you're not going to be able to see anything. It was scheduled for a blood search, and it was put down that none was obvious because on a black pair of socks, you're not going to see blood. It's going to be, at best, you might see something wet, but after a period of time and it dries, you won't even see that. So it was scheduled for a blood search. And what Mr. Douglas has on this chart is very misleading because it indicates that they have already looked for blood and that none is obvious. This is exactly the problem. Is that the jury is, and if Mr. Douglas had spoken to Mr. Matheson, he would tell him, we put it there, as many of the other items listed in this comments column, as a prospective plan. You can see on this list, it says just above it, the item number 12, swatch, RFLP possible, and on previous items, it shows RFLP would consume, PCR only. It's very obvious what this is. They're talking about what is capable of being done or what they plan to do. Not that it's been done, it hadn't been. So what counsel has put there is, again, completely misleading. It's the opposite of what occurred.
All right, let's take a look at the videotape and see what's there.
May I also request leave of the court? There was one chart we had not yet seen that we only saw a Xerox copy of. I wanted to address the court further on it, and I think I can do that better if I have the chart in front of the court. That was the chart entitled Deceptions, Distortions.
I thought you said you had no objection to that.
I had lost my copy of it at the time, Your Honor. There is language on it that I wanted to object to, not the entire chart, but certain language on it, and I need to confirm that that is on it. If it's not, there will be none. But that is the problem with not having everything in court on Friday as the court
counsel, is
requested.
there a reason you didn't tell me that you didn't have it in front of you when you asked me to rule on that?
I apologize to the court. I thought that...
I mean, I can't keep doing these things over and over and over again.
I'm only asking leave to see the chart as it currently exists. I have not seen the final hard copy. All we saw was a rendering on an 8 by 10 piece of paper. I would like to see what the final chart says.
Mr. Douglas, do we have that available?
I have it here. You know, the chart is being mounted right now and will be picked up this morning. But it just mirrors this particular chart.
Does the court have a copy of this?
No.
Do you have an extra copy?
No, that's the only one.
All right, would you hand that to Mrs. Robertson, please?
I want to address the court on certain aspects of this chart.
You know, we could put it up on the envelope.
Well, that'd be great. Let me first indicate, with respect to the first entry...
Hold on, I can't see the entire chart.
You can't either.
No, same thing.
That's good.
All right. Wait, focus that a little.
With respect to the first entry, Mark Furman and the gloves, it indicates plural. At no time did Mark Furman so testify, and the chart is misleading with respect to that language. The people object to the use of the plural. That never occurred. Secondly, Van Adder warrant. The search warrant and the circumstances of the search are irrelevant to the trial before the trier of fact. That is a legal issue that the court rules upon that is improper to raise in opening statement, let alone in trial. I would further mention to the court, I thought the court ruled that Mark Furman could not be mentioned in opening statement.
Correct.
And the people object on that basis as well.
Can I get a clarification out of that?
Furthermore, the Ron Phillips statement to the coroner. We're kind of not following procedure, but we're kind of asking a favor. A statement lifted out of context that is hearsay from a transcript that was issued by the coroner, not a statement made, not a report made by Ron Phillips, and is misleading and confusing on that basis.
All right. All right, Mrs. Clark, before you get too much further, counsel, this is an argument. This is not an opening statement exhibit.
Madam. Yes.
Good morning, Your Honor.
Good morning, counsel.
Your Honor, in this matter, it was my understanding yesterday that the people had an opportunity to look at everything. We did show this to them, and Ms. Clark indicated she had no objection. We don't want to be argumentative. This was passed, we thought, out of an abundance of precaution, if the court pleases, because we anticipated that she might change her mind. We have another chart, which I think the court will find hopefully less argumentative. I'd like for the court to take a look at it. I think this is what this is basically is a summary of the conduct. And I wanted one other query of the court with regard to Mr. Furman. The court did not say we could not talk about Mark Furman. I understand in the opening statement what you indicated was that with regard to the Kathleen Bell incident, I think you said, but you never said we couldn't talk about Mark Furman. Is that my understanding?
That's correct.
Okay, I want to make sure that was clear. May I show this to Mr. Hodgman and then give Your Honor a copy of this, what was proposed? Thank you.
Is this a change to this document?
Yeah, so change this document. You want to put it up there? Can we put it up for you? Let's put
Please.
it up. You got one? Okay, what's up now? Yeah. With regard to these items, the court will recall that as part of the exhibits, we will have a video clip of Detective Furman. If Ms. Clark objects to the use of the words gloves, I will stipulate to strike, make it glove, but we still are going to play that clip. With regard to Detective Phillips, we actually have a transcript. We passed this yesterday. That's already coming in. We don't want to take any out of context. People will be able to see exactly the transcript, so nothing's taken out of context. With regards to Detective Van Adder, where the statement is made that Simpson had left on an unexpected flight to Chicago. What we're talking about is not relitigating the issue, the court pleases, of the entry, but to indicate that in the very first contact with the criminal justice system at 10:45 on 6/12, an untruth was told. That in that warrant, under oath, they did not tell the truth. And we have that, and you saw yesterday Cato Kalin's statement. Your Honor, with regard to securing, documenting, and preserving the crime scene, everybody has been very much aware of that the trainee, Mazzola, was her third crime scene, was basically the officer in charge there. With regard to the Bronco, we've litigated this. Counsel has known for some time. We've made it in as innocuous language as we can that they failed to give that special care for evidence presentation. We showed all this yesterday, Your Honor. They went through it. They had no objection. The DNA testing, we've said consistently. They can talk all they want about DNA, but all the DNA evidence passed through the LAPD before it went to any other lab. And we think it's our right to talk about that. We have a chart that we've already passed on of the OJ's blood vial, and this mysterious blood vial and its saga, where it went, instead of being booked appropriately. And then finally, the question of the socks, whether or not there was none obvious in the socks. I disagree with my learned adversary that blood is red, albeit dark red. It's not black like socks. And you would be able, I suggest, to see it. And I think the question is, the prosecution thinks that they have a theory. And if we don't agree with that theory, they think they're always right. That's what a trial is about. That's why we're here, Judge. They're not always right. That's why they lose cases sometimes. And so they're not always right. The jury will make that determination. And this idea of protecting this jury, that's what you're going to do. We're not. You told us yesterday about doing our jobs. And that's when the system works best, Your Honor, as you well know. You do your job, we do our job, they do their job. We don't need Ms. Clark to do the job for the jury. They'll do their job, and you'll do your job. And I promise we'll do our job, Judge. And that's what you ask us to do. That's all we're trying to do here. This is a man that we have contended from the very beginning is wrongfully accused. And they are in for the fight of their lives. And so that this is not any game. And so we're very serious about this. We don't want to be argumentative, and we want to just spell it out. And we looked at this last night, even though she passed on this. We think we spelled this out, and I think it addresses all of the concerns, Your Honor. And I think that certainly an opening statement, one can't be precluded about what our theory of the case is in good faith. And so what we're doing now is much more than usual, Judge. They're having a total preview of the things we expect to use.
All right, let's see the videotape as well.
Thank you.
Let me see everything that I have to consider, and then I'll rule.
I haven't addressed the new chart on this.
I'd like to see the videotape. Thank you. Does this contain any,
I don't. No, Your Honor, this pretty much starts where the other one left off yesterday. The bodies have been removed, but the coroner is still there, and Mr. Fung is putting down his tags.
Mrs. Robertson?
Yeah, I think that contains all the clips that we wish to show in opening. There's a little more after this, but
Stop the tape. All right, Ms. Clark, I'll hear your objections.
First of all, with respect to the videotape, Your Honor,
Yes.
again, the same foundational problems we had with respect to time. We don't have the authentication in terms of the timing, and that's critical in terms of the evidence collection. The inference that the defense will seek to draw is that all of the evidence collected by LAPD was contaminated in some manner by the method, by the actions that are shown on the tape. If the evidence was already collected by the time these people are shown in the positions shown in the video, then there is in fact no impact, and the inference that they're seeking to draw is directly misleading to the jury. And that is one thing that in opening statement neither side is permitted to do. The people are not attempting to tell the defense how to try their case. The people are asking this court only to make sure that the jury is not misled, so that they get the truth, so that they understand what the evidence really is, not spin and not distortion and not half-truths or statements taken out of context, but the truth. And the problem with a video such as this one is that we have no way of knowing when it was shot, and the inference that the defense seeks to draw from it may be completely false, in which case the jury begins the case with a total misconception about the conditions under which the evidence was collected. And that is a very damaging thing, and that's why the defense, of course, seeks to do it, I understand. But it's not the appropriate thing to do. The jury deserves to get the truth and understand what the evidence really is.
All right, do you want to address the other issues, the SOC chart and the conduct chart?
Yes, the conduct chart, I think the SOC chart I have, Your Honor, I've addressed that. That is, again, totally misleading with respect to blood search. With respect to the chart, now the new one is even worse than the other. First of all, it repeats the misleading and completely false inference drawn about the blood search. They seek to argue in derogation of reality, in derogation of the truth. The truth is that it was scheduled for a blood search. What they seek to infer from this is that it was already conducted and none was obvious. And that is exactly 180 degrees opposite of the truth. So that is a complete falsehood. With respect to Mark Furman and the gloves, again, it's false. They state, they put on the plural, which was never stated by Mark Furman. They take his statement out of context. There's an extensive colloquy between himself and counsel in which he refers to one glove that he saw at the foot of Ron Goldman, and he says that repeatedly. And yet, taking one statement out of context, they seek to draw inferences from it. It's argumentative. It's not an opening statement, and it's misleading and unfair because it is taken out of context. The same would go for Ron Phillips to the coroner. Of course these are taken out of context. How could counsel argue to the contrary when you have a lengthy transcript of statements that have explanatory information both before and after? You have A and you have C and you take out B. And that's what counsel has done, taken everything out of its proper context and stuck it on a chart. And again, it's argumentative. With respect to the Van Adder warrant, that statement is irrelevant. We're talking about language in a search warrant that's appropriate for the court to rule on. That's not appropriate for a jury to be presented. The jury has to be the trier of fact to determine whether the defendant is guilty or innocent, not whether the search was proper or improper. That is a legal argument that goes to the court, not to the jury. That statement is inappropriate and it's argumentative as well. With respect to preserving the crime scene evidence, the defense, if they are saying the trainee is Andrea Mazzola was not in charge. She was a trainee who was being supervised by Dennis Fun. So this is false. This is a false statement if that is who they are claiming was in charge of the crime scene. That is untrue and misleading. I thought that the court's ruling pertaining to Mark Furman was that neither side could mention him. That was just Kathleen Bell.
The Kathleen Bell impeachment issue.
Okay. With respect to May I have a moment, Your Honor?
Certainly.
With respect to the items, failed to give special care, that's misleading as well. That's put in quotes as though it comes from a manual of some kind, which we know is not true, and it's argumentative. Yes, it's true, all evidence passed through LAPD. No objection to that. With respect to all blood not accounted for, that's argumentative. We haven't seen any evidence of that. If counsel thinks they can lay a foundation through the course of this trial, that's certainly appropriate for argument, but it's not appropriate for opening statement. And again, it's argumentative. I'm just waiting. Is the court?
All right, are you finished with your comments?
Yes, Your Honor.
All right, thank you. Mr. Cochran. Counsel,
Thank you, Your Honor.
I think we need an air traffic controller for the lawyers.
We do, Your Honor. We will be patient, Your Honor, at all times. Your Honor, in this regard, first of all, let me again point out, this is an opening statement, Your Honor, and whereas they have their theories, and we have not said they shouldn't have their theories. We think we have the facts, but certainly contingent upon that, we have certain interpretations of what we think the evidence is. As the court has so correctly stated, we are permitted to talk about those things. If you look at this chart, sometimes people shouldn't object if they have nothing to say. And in this instance, Your Honor, the issue, I already conceded with regard to using the word gloves. I don't want to mislead anybody. We'll take the S off. With regard to Detective Phillips, Your Honor, we have the entire transcript that we're going to have available. The court's rule, we can use that. With regard to Detective Van Adder, we're not relitigating anything. As I said, it's about credibility. And with regard to, and this is where counsel, who supposedly knows her case, should review to her own documents. I'd like the court to see this. Regarding Officer Mazzola, we have a form, 9408-17431, which says OIC name, officer in charge name A. Mazzola, assistant name D. Fung. We don't make these things up. I'll be glad to have them look at that. It's their form. Now, we don't make these things up. And with regard to the field of special care, she says, this in quotes, that's from the LAPD form, Your Honor. Remember yesterday when we showed the form, we pulled that up, where they failed to check the appropriate box when the Bronco was left basically unattended for all those months. Now, she conceded the DNA testing did pass through LAPD. Yes, it does, Your Honor. With regard to the blood vial, Your Honor, again, that is our belief based upon all the documents we've been given in discovery. And, if it turns out wrong, that's what we're going to say. This is based upon the documents we've received. It's not argumentative. That's our position, Judge. And she can't tell us what our position is or what it should be. She should understand that right at the beginning. And then with regard to the socks, we'll accept whatever language Your Honor says about that. But again, if you look at this particular form, Your Honor, this form is entitled OJ Simpson, Summary of Analyzed Evidence by Analysis Performed. We're using their own forms, Your Honor, by analysis performed. And it says under there that none obvious. And so that's all we've said. We took their own form. And so, there was a recent movie, Your Honor, where there's a line which I think is very appropriate in this case. I think it was A Few Good Men. We keep hearing about the truth. I don't think they can stand the truth. That's what Jack Nicholson said, that you don't want to hear the truth. And I think it's very appropriate in this situation. That's exactly what's happening here. Well, there's one other thing I'd like to point out.
Wasn't he the bad guy? Wasn't he the bad guy?
Yeah, but bad guys say something worthwhile sometimes, Your Honor. So even bad guys tell the truth on occasion, Your Honor. Certainly, we aren't the bad guys in this case, Your Honor. Your Honor, with regard to one other thing you'd ask us to do at the end of the day, and I believe this is on page 25 of Volume 2, Volume 11 of the reporter's transcript of proceedings from Thursday, July 7th, 1994. I'd ask leave of court to read this. It's Mr. Shapiro question. How much blood did you withdraw from Mr. Simpson? Answer, approximately 8 cc's. Question, when you say approximately, you did not measure the amount. Answer, well, it could have been 7.9 or it could have been 8.1. I just looked at the syringe and looked at about 8 cc's. You'd ask us to find that for you, and I'll give this to the clerk. But all we're asking to do, Your Honor, is to stop all of us haggling, and let's start with the opening statements. And we previewed everything, and I think it's time to resolve it. All right, thank you.
Thank you, counsel. All right, the objection to the use of the videotape is sustained. The argument has been that the concession has been that these are snippets and that the defense is willing to take the risk in argument that they cannot lay an accurate foundation. The problem is that leads to the danger of misleading the jury, and I'm not willing to take that risk during the course of an opening statement, so that objection is sustained. As to the SOC chart, the language that is on the SOC chart comes from a summary of reports and testing. It is not the report itself. The objection is sustained as to the language blood search none obvious. In all other respects, the SOC timeline chart may be used. As to the conduct chart, the objection is sustained. These quotes, some of these quotes are taken out of context, and there's a danger of misleading the jury as a result, so that objection is sustained. All right, counsel, I think that, I did not rule yesterday on the, Mrs. Robertson reminded me, I did not rule on the photograph of the defendant and 4 ladies in formal dress.
I don't say that the court did rule, Your Honor, that
I noted I didn't check it off on my list, and Mrs. Robertson indicated I didn't rule. So the objection on that, as to that, is overruled. So the record's complete. All right, counsel, that takes care of that. Let me just advise counsel, tomorrow one of our sequestered jurors has a medical appointment, and we will adjourn tomorrow at 3:30. 3:30 to accommodate that. And I would also like to talk to counsel at some point in time regarding your proposal regarding a scene view when you get the opportunity. All right, anything else before we invite the jurors to join us?
Your Honor, maybe
And the new chart will be people's next in order, photocopy of that for the record purpose. All right, Mr. Hodgman.
Thank you and good morning, Your Honor. Your Honor, first of all, there's a matter that we will need to approach sidebar. I think the court can handle it quickly, but it's a point of information I think all of counsel need to know before we proceed with opening statement.
All right.
Then, before we do that, Your Honor, before we do that, I'm sorry. Yesterday we raised a discovery concern with regard to the defense. This morning I've been provided with another witness statement from the defense, a memorandum from a Mr. William Pavlik dated November 2nd, 1994. I had asked the court yesterday that the court order that the defense turn over all discovery that's in their pipeline, so to speak, because we don't want to be surprised anymore. Now, I have asked Mr. Douglas this morning, is this it? Is there any other witness statement that they have, regardless of age? And I believe his response was he could not be definitive about it. Is that correct, Mr. Douglas? All right, I'll let him speak for himself. But what I would like the court to do is to remind the defense of their obligation to turn over to us witness statements, timely fashion. We're asking that everything be disgorged, as I did yesterday. And I would like to have that order made clear for the defense.
Mr. Douglas?
Your Honor, yesterday there was a specific reference made to an interview of a Scott Matsuda, whose name was added to the witness list, and I specifically had asked my investigator for that particular report, and I asked him to check to make sure that none of the names that were added, that there were any reports that had not been turned over. That was the report that I was given. That was the report that I turned over, and I will again endeavor to review my files, to review the files of the other counsel, and to make sure that there are not any other reports still outstanding that have not been turned over. And if I find so, I'll give them to Mr. Hodgman.
All right, I would like for you to report back to the court tomorrow morning, Mr. Douglas, as to that search.
Yes.
All right. All right, Mr. Hodgman, can we approach now?
Yes.
Thank you. Yes. We'll stand in recess until 10:30, and we will begin opening statements at 10:30. All right, Deputy Jex, we need the jury, please. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Allman, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. The jury is not present. Deputy Magnero, may we have the jury, please?
Quiet, boys.
All right, counsel in the audience, please be seated. All right, good morning, ladies and gentlemen. We are going to begin with the opening statements made by the lawyers in the case. Let me remind you from my instructions to you yesterday that any statements made to you by the attorneys during the course of their opening statements are not evidence and should not be considered as such by you. These opening statements are normally given by the attorneys to sort of give you an overall view of the evidence that they intend to present. It's to give you a roadmap, so to speak, as to how to evaluate the evidence. This case, as you know, will be relatively long, and by necessity, some of this evidence will be presented to you out of chronological or logical order. So they'll need to explain to you the case that they intend to present. All right, are both sides prepared to go forward, Mr. Cochran?
We are, Your Honor.
Mr. Clark?
Yes, we are, Your Honor.
All right, do the people wish to make an opening statement?
Yes, we do.
All right, you may proceed. Mr. Darden? Thank you.
Your Honor, Judge Ito, Mr. Cochran, and Mr. Shapiro and Dean Ullman, and to my colleagues seated here today in front of you, and to the real parties and interest in this case, the Brown family, the Goldman family, and the Simpson family, and to you ladies and gentlemen of the jury, good morning. I think it's fair to say that I have the toughest job in town today. Except for the job that you have. Your job may just be a little bit tougher, but your job, and like my job, both have a central focus, a single objective, and that objective is justice, obviously. It's going to be a long trial, and I want you to know how much we appreciate your being on the panel. We appreciate the personal sacrifices you're making by being sequestered. We understand that can be difficult. And I'd like to thank you in advance for keeping the promises you made to us when you were selected for the jury initially. You promised to be fair. You promised to be open-minded. You promised to hear and see and carefully consider all the evidence in the case. And you promised to find this case, to come to a verdict in this case solely on the basis of the evidence and the law given to you by Judge Ito. And you promised to do that based on the law, based on the facts and the evidence, and nothing else. You promised us that you had no hidden agenda, that you only wanted to see justice done, and you promised us that you would do everything you could under the law to see that justice was done. And so I thank you for that, and I thank you in advance for the verdict you will at some point render in this case. And we're here today, obviously, to resolve an issue, to settle a question that has been on the minds of people throughout the country these last 7 months. It certainly has been on the mind of my people up in Richmond, California, and friends in Fayetteville, Georgia, and all across the country, and everybody wants to know, and everybody I know often pose the question to me, did OJ Simpson really kill Nicole Brown and Ronald Goldman? Well, finally, ladies and gentlemen, I am here in front of you this morning to answer that question. And we'll answer that question from the witness stand, and from the exhibits you'll see in this case, and from the evidence. And when you see the evidence, and when you hear the witnesses, and when you put it all together and consider the totality of circumstances in this case, the answer will be clear to you as well. The answer to the question is yes. The evidence will show that the answer to the question is yes. OJ Simpson murdered Nicole Brown and Ronald Goldman. And I'm sure you'll be wondering why as the trial proceeds on, and I'm sure you're wondering why right now. As the judge instructed you already, opening statements are not evidence. Opening statements are given by lawyers, and in an opening statement, we inform the jury of what we think the evidence will show in this case, what we believe the evidence will show. But we're lawyers. We're not witnesses. We're not under oath. Nothing we say is evidence. The things we say to you today are not the things that you should carry into the jury room and into deliberations. You should carry into the jury room and into your deliberations the evidence in the case, the testimony from the witness stand, the exhibits admitted at trial, the instructions given to you by the court. And when you look at all of that, when you go back and reflect on the testimony and the exhibits and everything you heard and saw in this case, you'll know why he killed Nicole Brown and Ronald Goldman. And when I give you the answer as I have, and you consider and you stop and consider and you think, why would he do it? Why would he do it? Not O.J. Simpson, not the O.J. Simpson we think we know, not the O.J. Simpson we've seen over the years. But that raises another question, and that question is, do you know O.J. Simpson? We've seen him play football for USC. We watched him thrash UCLA and play in the Rose Bowl. We watched him win the Heisman Trophy. He may be the best running back in the history of the NFL. We watched him leap turnstiles and chairs and run to airplanes in the Hertz commercials. And we watched him with a 50-inch afro and Naked Gun 33 and a half. And we've seen him time and time again. And we came to think that we know him. What we've been seeing, ladies and gentlemen, is the public face, the public persona, the face of the athlete, the face of the actor. It is not the actor who is on trial here today, ladies and gentlemen. It is not that public face. It is his other face. Like many men in public, like many public men, they have a public image, a public persona, a public side, a public life, and they also have a private side, a private life, a private face. And that is the face we will expose to you in this trial. The other side of O.J. Simpson, the side you've never met before. We will expose in this trial and show to you in this trial that other face, the face he wore behind the locks and the gates and the walls at Rockingham, that other face, the one that Nicole Brown encountered almost every day of her adult life, the one she encountered during the last moments of her adult life. The same face Ronald Goldman encountered during the last moments of his life. When we look upon and look behind that public face, the public face of the man who sits here in court today, you'll see a different face. And the evidence will show that the face you'll see and the man that you will see will be the face of a batterer, a wife beater, an abuser, a controller. You'll see the face of Ron's and Nicole's murderer. To understand what happened at Bundy, we need to examine this defendant's relationship with Nicole. Because when we do, we can discern from that, we can see a motive. We can see his motive for killing his ex-wife. And I submit to you, ladies and gentlemen, that as the trial proceeds on, and as you hear the evidence in this case, that motive will become clear. He killed Nicole for a single reason. Not because he hated her. He didn't hate Nicole. He didn't kill her because he didn't love her anymore, because in his mind, he did. He killed her for a reason almost as old as mankind itself. He killed her out of jealousy. He killed her because he couldn't have her. And if he couldn't have her, he didn't want anybody else to have her. He killed her to control her. Control is a continuing theme. It was a continuing theme. The central focus of their entire relationship. By killing Nicole, this defendant assumed total control over her. By killing her, he committed the ultimate act of control. By killing her, no one else could have her. No one but him. And he killed Ron Goldman. And he killed Ron Goldman for another reason. He killed Ron Goldman because he got in the way. He killed Nicole because he had a problem with her, as men and women sometimes do have in relationships. They have a problem. And this defendant's problem, the man in the courtroom, I think he stated his problem rather eloquently. He had his weight, because he stood over her body and his weight. And he said then, and he said on other occasions, and I quote, he said, while standing over that casket, while standing over Nicole's body, my problem was that I loved you too much. But it wasn't really love, ladies and gentlemen. And this will be reflected in the evidence, and the evidence will establish this, that it wasn't really love. What this defendant had for Nicole Brown wasn't love, it was obsession. He became obsessed with her. And his obsession was so great that he developed a need to control her. And his need to control and his feeling of obsession, this obsession was so great that when he came to realize that he could not keep her, he killed her. Because to let her go would mean to lose control of her. To let her go with Ron Goldman or someone else would mean to lose control. He couldn't have her. And neither could anyone else. Now, the evidence in this case will establish that the man in the courtroom, this defendant, is an extremely controlling and possessive man. And as I said before, control and possessiveness was a single dominant theme throughout their relationship. And he controlled her in a variety of ways. He controlled her financially. When the defendant and Nicole first met, she was barely 18 years old. He was almost 30. She shared an apartment. He owned a mansion. She waited tables at a restaurant. He was a millionaire. No one had ever heard of Nicole Brown, but he was one of the most recognized men in America. But after he met her, he slowly began to control her. She shared an apartment with a friend. He got her own apartment. He bought her things. He gave her things. The time she was 19, she was driving a Porsche. He got it for her. He began to gain control over her. And throughout the years, throughout their relationship, he maintained that economic control over her, that financial control. The evidence will show that Nicole never really held a job. She never really worked. She never really operated a business. She never had an income really of her own. Throughout her entire adult life, this man, the defendant in the courtroom, held the purse strings in her life. Whatever money she got, whatever material possessions she got from the defendant. People can sometimes be bought. And young people sometimes can be easily misled. Nicole was a very young woman, if a woman at all, when she first met this defendant, the man seated in the courtroom. And as the years went on, and as they continued to date, and as he gained more and more control over her, the more control he gained, the more abusive he became. As you listen to the evidence in this case, you're going to be hearing evidence regarding domestic abuse, domestic violence, stalking, intimidation, physical abuse, wife beating, public humiliation. As you listen to the trial and as you hear this evidence and see this evidence, please keep in mind that all of these different kinds of abuse were all different methods to control her. Let me proceed on. The evidence will show in this case that he abused her mentally. He stripped her of her self-esteem. This defendant dictated the way Nicole would dress. He dictated the way she would wear her hair. And when he didn't like her appearance, he would criticize her, he would humiliate her to the point that she would cry. If he didn't like her shoes, he'd go out and buy shoes. This is what I want you to wear. Wear this, look like this. She was not a Barbie doll, ladies and gentlemen. The evidence will show that he was so controlling that he attempted to define her identity. He attempted to define who she was. When she was pregnant and put on weight. The evidence will show that this defendant was so abusive that he called her names. He called her fat. He called her a pig. And he did this in the presence of her family and in the presence of her friends. And he humiliated her. That is the face we intend to expose in this trial. That's the other side of this defendant we're going to show you in this trial. And by doing these things and by hurling these insults, he stripped her of her self-esteem. And when you're controlling someone financially, and when they have no self-esteem, and when they have no identity, you have them. You control them. The evidence will show that this defendant, this man in the courtroom, was a very controlling and possessive man. And that the dominant theme throughout their relationship was his control with Nicole Brown. But he did more. He did more than just demean her in the presence of others. He attempted to isolate her, sometimes from some people. When certain men came around, he became jealous. And he became so jealous that it got to the point that she would not agree or want to be around certain men because she was concerned that he might get jealous by their mere presence. And as time went on, and as he became jealous, and more jealous, he even insisted that she not be around certain men. He began to isolate her, ladies and gentlemen. When her friends came around, her girlfriends came around, and when he felt that she was spending too much time with those girlfriends, he talked to the girlfriends. He let them know he didn't like them hanging around. He dissuaded her girlfriends from hanging around. He attempted to isolate her from other people. And when you isolate someone, and when you have economic control over someone, and when you strip someone of their self-esteem, and when you establish their identity, you have them. They're yours. You can control them. And the evidence would show in this case that this man is an extremely possessive and controlling individual, and that he is an extremely obsessive individual when it came to Nicole. And his obsession was manifested by the things he did toward controlling her, but demeaning her and controlling the purse strings and isolating her and defining who she would see and who she wouldn't see and who her friends would be and who they would not be wasn't all this defendant did to control this woman. There are more powerful forms of control. There's force. There's violence. There's fear. There's intimidation. And you will hear testimony. You will see evidence that in his quest to control Nicole, this defendant used all these things. He used fear. He used intimidation. And he used violence. And he instilled such a fear in her, ladies and gentlemen. She heard testimony that he could walk into a room. He could walk into a room, and Nicole would be there. And a moment before he walked in, she would just be the most charming individual there is, relaxed. But when he walked in, her demeanor changed completely. As time went on, his mere presence became intimidating to her. I mentioned earlier that they met when she was around 18 years old back in 1977, and they dated for 8 years. And they eventually married in 1985. And the marriage was a stormy marriage. And it was a marriage punctuated by acts of violence. And that violence would always be followed by an apology. He would apologize, give her jewelry, buy her flowers. He would promise to do better. Promise to maintain control of himself. And he would promise not to do it again. And then those acts of violence would be followed by additional acts of violence, and it became a cycle. Violence, apologies, a period of quiet and calm, then violence and apologies, quiet and calm, violence, apologies. Quiet, calm. A cycle of violence characterized their relationship. It characterized their marriage. And domestic violence, ladies and gentlemen, that's a difficult topic, because domestic violence is something that happens behind the gates and the walls. It happens in the bedroom and inside the home and in places where the public can't see. Domestic violence is a private affair, generally, while it's occurring. And so it makes it difficult to obtain evidence, to gain proof that the violence occurred. And it makes it difficult to obtain evidence and gain proof that the relationship is a violent relationship. But we do have that proof. We do have proof. We do have evidence. You will hear testimony from witnesses in this case, and they will discuss the violent relationship, the violent marriage this defendant had with Nicole Brown. In 1985, the police responded to the defendant's home on Rockingham in response to a call. And when they arrived, they were met by Nicole. She was crying. She was upset. And her face was puffy. She was near hysterics. She told these people, she said, we had a fight. After the fight, I was trying to leave, and when I tried to leave, the defendant grabbed a baseball bat, and he took that baseball bat and smashed the windshield to my car. This is 1985. And as they looked around, these law enforcement officers, they looked to the right, and they saw a white 450 SL Mercedes-Benz. And the windshield was smashed out. And just then the defendant came out of the house. And he offered an explanation. Well, the police didn't arrest him. They left. They left Nicole there. They left the defendant there. And that isn't an act of physical violence toward Nicole, is it? Or is it? Maybe it is. Nicole Brown was there to witness this act, this violence on her vehicle. And if you're married to someone and you love someone and you have a fight with them and they take a baseball bat and they do something like that to one of your prized possessions, could it be that they're sending a message? The evidence will show that this was a message. It was an indication. It was a warning as to what would happen next. It was a warning that what happened to this Mercedes-Benz could just as well happen to you. And it did happen to Nicole. Not with the baseball bat, but just like that Mercedes got smashed and dented, so did Nicole. You'll be hearing evidence. You'll be hearing testimony. You'll be seeing witnesses in this case regarding an incident that happened on January 1, 1989. It was almost 4 o'clock in the morning on January 1st when the 911 operator received a telephone call from Rockingham. And that operator will be here to testify in court. And that operator will be here to authenticate the tape of that 911 call to Rockingham. And when the operator appears, and when the tape is played, listen very carefully. Because if you listen carefully, in the background, you will hear a woman screaming. And you will hear something else. You will hear the sound of this defendant, this man, beating this woman. You will hear the sound of his hand smacking across her face. You will hear the sound of this defendant beating his wife. The police arrived. They arrived at Rockingham in response to that telephone call. Nicole never got to tell the 911 operator to come and help me or anything like that. All she did was scream, and the operator could hear her screaming, and the operator could hear her being beaten. And she advised LAPD units to respond to 360 North Rockingham. We can hear the sound of a woman being beaten now, right now. And the officers arrived at Rockingham a short time later. And when they did, they rang the buzzer to the security gate. And as they did so, they saw someone run from the bushes, run from the darkness in their direction. And this person that they saw was Nicole. And Nicole came running out of the darkness wearing nothing but sweatpants and a bra, running toward the officers. And she was covered with mud, and she was dirty, and she was filthy, and she ran toward the officers. And as she ran toward the officers, she was shouting and yelling, "He's going to kill me. He's going to kill me." And the officers stood there. They didn't know what to do. It's 4 o'clock in the morning. She's out in her bra. Sweatpants are covered with mud. They just got a call. There's a woman in Rockingham being beaten now. She comes running out of the darkness and out of the mud and out of the bushes. And she pushes a button to the security gate, and she runs through the gate, and she collapses in the arms of the officer. The entire time she's yelling, "He's going to kill me. He's going to kill me." And the officer said, Who's going to kill you? And she said, "OJ is going to kill me." And the officers looked. They looked at Nicole. Her eye was swollen, bruised. Her lip was cut. One of the officers, the senior officer there, he looked at her neck. And what he saw startled him. On her neck, he could see the imprint of a hand. The imprint of a hand around her neck. Well, it was then that the defendant came out of the house. He was wearing nothing but his bathrobe. And he did not address his wife at the time. And he did not ask the police how she was doing or if she was okay. And what the evidence will show, and what you will hear in this case, is that he demeaned and humiliated her even more. He shouted to the officers in the presence of Nicole, his wife, "I've got 2 women now. I don't need that one. I don't want that one in my bed anymore." This was his wife, and this is what he said to these officers who were strangers to him. This is what he shouted out to the police. The officers were on one side of the gate of the wall, and the defendant at that time was on the other side. The officer said, "Mr. Simpson, we're going to have to place you under arrest. It appears that your wife has been beaten. So please go back into the house and put on some clothes and come with us. We're going to take you to the station." Well, the evidence would show that that did not fit well with this defendant. And he responded, "The police have been here 8 times before. And now you're going to arrest me for this?" 8 times. That's what the defendant said. The police had been there 8 times before. And as he said, "You're going to arrest me for this?" The defendant told the officers, "This is a family matter." That's what the evidence would show. The defendant said to the officers, "This is a family matter." And he asked, "Why do you want to make such a big deal out of it? We can handle it." The evidence would show that the officers did not like the way he had handled things up to that point. And they insisted that he get dressed. And they told him that he was under arrest and that they were going to take him to the station. But this was OJ Simpson. And he did get dressed. But he didn't go to the police station. He jumped in his Bentley and he sped away, and they chased after him. They didn't catch him, and he got away. The next day, he went to the Rose Bowl. But despite this, despite 89, what happened on January 1, 89, despite the Mercedes-Benz incident in 1985, she stayed. She stayed with him. And I'm not suggesting, and the evidence won't suggest, that every day of their marriage or their relationship is stormy, rocky, and filled with violence. That's not what we're suggesting here. But we are suggesting, and the evidence will show, that there was a cycle of violence. A cycle of violence, and the dominant theme in that relationship and in that cycle, and the ultimate objective was always control. Control. Well, after the 89 incident, after that night, their relationship changed somewhat. She was concerned. And the defendant was concerned. The defendant is a public man, and he was concerned about his public image. And in the public domain and in the public media, back in 1989, he was interviewed by Roy Firestone on ESPN. And during that interview, Mr. Firestone asked the defendant about that incident on the morning of January 1. And the defendant downplayed it. He minimized things, bluffed it over. And you'll hear and see that interview. And in that interview, the defendant said it was sort of a mutual wrestling match. She was wrong, he was wrong. Ta-da. No big deal. And that's what he said to the press, to the public. He minimized things. But you'll hear testimony from investigators employed with the DA's office, and they'll tell you about a day just a few months ago when they drilled a hole in the safe deposit box, Nicole's safe deposit box. And they'll tell you about the day that they recovered photographs taken of Nicole's injuries back in 1989. And they'll also tell you about the recovery of some letters the defendant wrote to Nicole after the 1989 beating. And you'll see those letters. They'll be here You'll be able to read them, and you'll note that the account the defendant gave the press and the media and the public was not the same account he gave Nicole in those letters during that apology phase, the contrition phase, the phase he was going through. In the letter he wrote to Nicole, he apologized for hurting her. In the letter he wrote to Nicole, he admitted he had lost control. And in the letter to Nicole, he said the same old thing you've been saying all along, and that is that I will do better. We can get through this. And that happens in bad relationships and in abusive relationships, doesn't it? Things get bad things happen. It's always somebody's fault. But nobody wants to take the blame. And in this situation, and the evidence will show that what the defendant did was he made these promises, sort of roped her back in. You know how it is. Bad relationship, I'll do better, here's a gift, I'm sorry, and they just rope you back into it. And if you're the other person in Nicole's position, as she was, and this will be reflected in the evidence, she wanted to believe. She wanted to believe that her marriage could survive. She wanted to have hope, and he gave her hope for a while. Because this is a cycle. And so he beat her up on January 1, and he admitted to her privately in his letters that he was responsible. And he apologized, and he gave her things, and he tried to make it all better, and he gave her hope, and he roped her back in, and she stayed. She stayed because she had hope and because she wanted to believe that January 1, 1989 would be the last time that he would abuse her, physically or mentally. As you hear the evidence in this case, something very sad becomes very apparent. They met when she was 18, and he was almost 30. And in 1992, they divorced. She was only 33 or so. And she died when she was almost 35. Throughout her adult life, throughout most of her adult life, her concept of marriage and a relationship was defined by this defendant. That was adult love. Her notion of adult love for 15 years was what this defendant gave her. And he abused her throughout that relationship. Well, as I said before, sometimes you get roped in, people get roped in. Nicole got roped in by the defendant, and she stayed, and she stayed. And people stay in those situations, those abusive relationships, for years and years, until one or two things happen. One, they just can't take it anymore. Or two, until they just can't take it anymore and they wake up to reality. And finally, in 1992, Nicole woke up to the reality of her situation. And in January 1992, she moved from Rockingham, and she left the defendant, and she filed for divorce. Well, this did not sit well with this defendant, and this will be reflected in the evidence. He did not like this. He did not like the fact that Nicole was leaving his house, going somewhere else to live in her own house, away from him. There's that issue of control. How could he control her? She wasn't right there with him. And he didn't take it well, and he lost 20 to 25 pounds like that. And almost on a daily basis, he would call her sisters, Dominique and Tanya and Denise, and he'd call her mother and her father, sometimes crying on the telephone. And he would call them, and he would whine to them, and he'd tell them how much he loved her and how he wanted her back. He'd use them, try and rope her back in. Well, she couldn't let him go, not completely. I mean, how could she? She's been under his control for 15 or 16 years. And so she didn't go too far. She rented a house in Brentwood on Gretna Green. They saw each other. They had children together, lovely children. You'll probably be seeing a picture of one pretty soon. But he couldn't deal with the loss of Nicole. He couldn't deal with not having her there. He couldn't deal with the loss of control, and he couldn't help but pursue her. You'll hear a testimony in this case from Nicole's mother, and she'll tell you about some of the telephone conversations she had with the defendant back in 1992, and some even more recent. And in one conversation, he told her, he said, all my friends tell me that I should just leave her alone, just forget about it, just go on with my own life. And when Mrs. Brown said, why don't you do that? Let her go. If you let her go, then maybe she'll come back to you. Just let her go and maybe she'll come back. And his response was, I can't. You know I can. You know I can't help myself. I can't let her go. He couldn't let her go. He couldn't help but pursue her. He couldn't leave her alone. He couldn't handle the loss of control. And because she had left his house and moved somewhere else and established her own home, her own house, and began establishing her own relationships, he did the only thing he could do to gain control, to try to regain control, to try to find out what was going on with her. And so he stalked her. He stalked her. When she left Rockingham in January of '92 and set up a new household on Gretna Green, also in Brentwood, she began dating a man named Keith Zalamzowicz. And she got a babysitter for their 2 children. Whenever Keith and Nicole would go out, not every time, but enough, he would show up. They went to a nightclub, and Keith will tell you about this. He'll be here to testify. The defendant showed up. They went to a restaurant called The Tryst. It had just opened. Nicole and Keith and some other friends, they were there. They got a table. They began to have dinner. And as they sat there having dinner, guess who showed up? Guess who attempted to gain control again? The defendant showed up. And that'll be reflected in the evidence and in the testimony. And what he did is he walked into the restaurant. He saw Nicole and Keith and her other friends. He went to another table. He grabbed a chair. Now, the chair was facing in an opposite direction, but he grabbed the chair. He turned it around. He sat there staring at Keith and Nicole and their dinner party. Well, Keith will be here to tell you that that was an awfully intimidating experience. Why? There was another incident at the Mezzaluna. Nicole was there, Keith was there. The defendant suddenly showed up, drove up in front of the restaurant, got out of the car, walked up to the table where they were seated, put his hands on it and said, "I'm OJ Simpson and she's still my wife." Well, she'd filed for divorce and moved out of his house. That was intimidating. And there's more. And you'll hear about the other incidents. There's more evidence of stalking in this case, and you'll hear about that. There was one evening when Keith and Nicole, they went to a comedy show, and after the show, they went to Nicole's house on Gretna Green. It was about 3 a.m, and they were seated on the sofa in her living room. The kids were upstairs asleep. It's 3 o'clock in the morning. And Keith and Nicole made love on the couch. But they weren't alone. There was somebody watching. There was someone watching through the window. It was the defendant. At 3 o'clock in the morning, he was looking through Nicole's window, watching her make love to another man. And the next day, when Keith and Nicole were together, he walked right into her house. And he was beside himself, and he was angry. He said some very naughty things. But one of the things that he said to Keith and Nicole was that he said, "I watched you last night. I watched you and I saw everything." The evidence will show that that is some unusual behavior, to say the least. But the evidence will show also that this is all part of this cycle. It is all part of this dominant theme in their relationship. This is all part of his need to know everything about her, to know where she is, to know who she's with, to know what she's doing, to control her. It's control. It's all about control. And though he did not interrupt them during the middle of the act, and he didn't punch Keith out, and he didn't punch Nicole out, he still watched so that he would know. And to control her, he had to confront her with what he knew, to intimidate her, to keep her from doing it again. It's all about control. Well, over the months, Nicole still wanted to believe that they could be a family again together. And they would attempt reconciliation, and they would fail, and they would attempt again. And Nicole was as much a party to that as the defendant was. But there was a situation in October of 1993, an incident another control incident. He forced his way through the back door of her place on Gretna Green. He forced the door in. He entered her house without her permission, without her knowledge, and he confronted her, and he scared her. He frightened her, and he scared her so badly that she telephoned 911. And she asked for police assistance, and you will hear that tape, the tape of that 911 call, and you will meet the 911 operator. And you will hear the defendant in the background. This is October 1993. He watched Keith and Nicole have sex in April of 1992. And when you listen to the October 1993 911 tape, you can hear him in the background still yelling and shouting about what happened in April of 1992. But that 911 tape is a telling glimpse into their relationship. That's for sure. And it's also an example of this defendant's private side, his private face. The other man, the man in the courtroom, the man that's on trial here today. And you'll hear Nicole on the telephone talking to the operator. And as you listen to her, you can't help but discern from the tone of her voice and the things that she says that she's a tough woman, but that she's also afraid and intimidated. And not only that, but that she feels that her situation is hopeless. The evidence will show that by October of 1993, Nicole, her situation was hopeless, and she was helpless. Way back in 1989, the defendant said that the police had been to the house 8 times before and never done anything. Nicole said the same thing on the telephone to the 911 operator in 1993. Her situation was hopeless and she was helpless. And you can infer from the evidence that Nicole Brown expected or had no expectation that anyone would ever do anything to this defendant because he beat her. There was no help coming and she didn't expect any help. But you'll hear that telephone call and you will hear the defendant and you will get a true sense of the fear he instilled in her. And he didn't hit her that day. He didn't strike her and he didn't punch her. He did go through the house to see who was there. But he didn't hurt her that day. Still, she stayed. Still, they remained involved. Not only in the sense that he was the father of her children, but they still attempted to reconcile. And over the months after October of 1993, they tried to get together and they failed. They tried to get together and they failed. And in May of 1994, it was Nicole's birthday, and the defendant gave her a very nice gift, a piece of jewelry. And they attempted to reconcile, for lack of a better description. But the evidence will show that it was a very brief attempt, because a few days later, Nicole called it quits. She woke up to the true reality of her situation. She couldn't be bought anymore. She couldn't live like that, and the evidence will show that she let the defendant know that it was over. This is it. Hasta la vista. And this was significant in the mind of this defendant, ladies and gentlemen. It was something that had never happened before. He would do things to her and he would try to appease her by giving her things. She would accept those things and they would reconcile. But not this day. This day, she couldn't be appeased. She couldn't be bought. She couldn't be bribed. She had around and sat in it, and he sat there facing Nicole and he just stared at her. He just sat there staring at her. And you'll hear testimony about this, and the evidence will show that it was a menacing stare. a penetrating stare. It was an angry stare, and it made everyone very uncomfortable. When the recital was over, there was a little issue of whether or not the defendant was allowed to give Sydney some flowers, and he gave her some flowers. But the Brown family had decided to go over to the Mezzaluna restaurant for dinner. And as they left, they made it clear to the defendant that he was not invited. And he wasn't invited. And by not inviting him, it was a reaffirmation of what he'd already been told, and that is that it was over. He was no longer being treated as a part of the family. He was no longer the centerpiece of every family outing. Nicole was getting on with her own life. And as the Brown family left, they looked toward the defendant and they saw him, and he was angry and he was depressed and they were concerned, and everyone wondered, what is he up to now? Well, Ms. Clark will tell you exactly what the defendant was up to as the day proceeded on. But there are some things you should know about this evidence that, as you hear it. This is not character assassination. This is evidence of a controlling personality, of a controlling relationship. It's proof of jealousy. And as Ms. Clark talks, and as the evidence develops in this case, and as you hear it and see it and process it, you'll see that cycle of violence. You'll see how things escalated. You'll see how controlling he is. And you'll see why he would kill on June 12th. This is not character assassination. This is not some tabloid prosecution. The evidence you will hear in this case will be evidence of this defendant's life, of his conduct, the things he did. You hear evidence of his relationship with one of the victims. And as you hear it, as you hear the evidence and as you listen to Ms. Clark, you'll see how it is that Ron Goldman happened to be at the wrong place at the wrong time. As you listen to the evidence, you'll see that his decision to kill finally was merely a final link in a progressive chain of abusive and controlling conduct. And it was a chain that consisted of fear and intimidation and battery and emotional and mental abuse and economic abuse and control and stalking. And you'll see that there was a common scheme, a common plan in all of this, and that was to control her. It was all designed just to control her. And in controlling her, it was the private man, private OJ Simpson. It was the defendant who committed that final, ultimate act of control. She left him. She was no longer in his control. He was obsessed with her. He could not stand to lose her. And so he murdered her. And as you hear the evidence in this case, it will become clear that in his mind, she belonged to him. And if he couldn't have her, then nobody could. Thank you.
Ms. Clark?
Good morning, ladies and gentlemen. We've all seen him for quite a while, but hadn't seen Mr. Jardine. He was busy with other matters, and he is an integral member of our team. Let me introduce some of the other lawyers who haven't met yet, but you will be seeing through the course of this trial. Mr. Hank Goldberg, Mr. Woody Clark, and Mr. Rodney Harmon. They will all be presenting with the scientific evidence in this case that relates to the blood analysis and DNA testing. When you hear the amount of evidence that we have, you'll understand why I need the help. And I thank them very much for their able assistance thus far. Of course, you know Mr. Hodgman. He's still here. You've now heard the why. You've heard why. Why would Orenthal James Simpson, a man who seemingly had it all, commit such heinous crimes? Throw it all away. The one simple truth about the evidence described to you by Mr. Darden is that it shows that Mr. Simpson is a man, not a stereotype, but flesh and blood, who can do both good and evil. Being wealthy, being famous cannot change one simple truth. He's a person, and people have good sides and bad sides. Whether you see both sides or not, both sides are always there. Now, we will show you the other side of the smiling face you saw in the Hertz commercial, the one you never saw on camera, the one none of us ever wanted to see. And that was the side that went from Rockingham at his estate to Nicole's home at 875 South Bundy on the night of June the 12th, 1994. Now, on that night, many events were happening at the same time. And in order to give you a true picture, the most clear and accurate picture of what really happened, how the events occurred, I'm going to go back and forth between the parties and between the locations. So what I want to do, first of all, is describe the setting for you. As of June the 12th, 1994, Nicole was living at 875 South Bundy in Brentwood. That's a condominium. It was a duplex, and so it's one building. She had one side, had a common wall, and her neighbors had another side. She lived there with her two children, Justin and Sydney. The defendant was living at 360 Rockingham Avenue in Brentwood. Brian Kalin, known as Cato, some of you already are familiar with the name, was living in one of the guest units behind the defendant's home on Rockingham Avenue. The defendant's daughter, Arnell, lived next to Cato in another one of the guest units. I'll show you a diagram a little bit later to get you more familiar with the location, but the guest units are behind and apart from the main house, and they share common walls. It's kind of like one long building. So Cato had one, and then Arnell had the next one. Now, the background on Cato, and the evidence we'll show you, is the following. Cato met Nicole in 1992 after she had left the defendant at a party in Aspen. They remained friendly after that point, not romantically, platonic, just friends. And he went to a party that she gave in Gretna Green in 1993. He noticed that that house had a guest unit behind it that was a separate living quarters, and he asked Nicole if he could rent that location. She said yes. She rented it to him for $450 to $500 a month, and he was allowed to reduce that amount if he did babysitting for her. He was very good with the children, so that was an arrangement that worked well for everyone. However, Nicole decided to move out of Gretna Green in 1994, and she found the residence on Bundy that I've described to you. Now, the Bundy residence did have separate quarters with its own entrance and exit, but it was all under one roof. It didn't have a separate living quarter like the other house did on Gretna Green. The defendant asked Cato not to stay there, not to live under the same roof as Nicole, saying it wouldn't be appropriate. And he asked Cato to come stay in one of the guest units at his house on Rockingham. He told Cato he could stay there for free. Cato, obviously, saw a much better financial situation for himself and agreed. And so in January of 1994, Cato moved to the guest unit behind the defendant's house on Rockingham, and Nicole moved to 875 South Bundy. Let me show you a board now of the Rockingham location.
Oh, sure. Would you like to see?
Yes, I know, just so that which ones.
It's fine.
Thank you very much, Your Honor. Thank you, counsel.
We have a number on it.
So we can tell which one it is.
Shall I mark it now?
Let's just,
Or I just describe it? 360 North Rockingham Avenue.
This is an overall diagram of the defendant's home on Rockingham Avenue in Brentwood. This location here, this area here, is the main house. These rooms that are shown down here are the guest units. Now the guest units close off. They are locked off with a door so that you can't enter from the guest unit into the main house. You see the area here, it's marked Kalen's room. I don't know if you can all read it, that's why I'm pointing to it for you. That is Cato's guest unit. Right next to his unit is a...
Art, could you allow Mr. Cochran to step over to your right so that he can see what you're pointing at?
That's a good idea.
Second.
Thank you, Ron. This is an office that Cato had access to. And this would be Arnell's room, right next to Cato's. Now, the Rockingham address also had a gate that opened onto Ashford Street on the north, and a gate that opened onto Rockingham on the west side. I'll get into more detail about it a little bit later. Now, before I really get into the events of the night of June the 12th and into all the details, there are a few key points that I want to bring out to you right now. I'll come back to them again, but I want you to bear them in mind. This has to do with the timing of the events that happened that night. You're going to hear a lot of talking about that throughout this trial. I think I can guarantee that. With respect to the timing, the evidence will show that on the night of June the 12th, 1994, the defendant had an hour and 10 minutes of time in which his whereabouts are unaccounted for. And we will show that it was during that hour and 10 minutes that the murders were committed. And so the evidence will prove that Cato last saw the defendant on the night of June the 12th at 9:35 at the latest. He did not see the defendant again until after 11 o'clock. In between those two times, at 10:15, a dog is heard barking that the evidence will show was Nicole's dog, which fixes the time at which the murder occurred. At 10:45, Cato heard thumps on his wall. And shortly after 11, he saw the defendant. An hour and 10 minutes during which the murders occurred, in which the defendant's whereabouts are unaccounted for. I'll come back to that point. Now, on the night of June the 12th, as Mr. Darden has already described to you, that was the recital for Sydney. It was a dance recital for her school. On the morning of June the 12th, the defendant played golf played cards, and he was scheduled to go to the recital at 5 p.m. on the evening of June the 12th. Mr. Darden described to you how the defendant behaved that night. He was in an ugly mood, morose, depressed, and clearly fixated on his ex-wife, Nicole Brown. He returned home after the recital, and he spoke to Cato. It was approximately 6:30 to 7 p.m. He returned home to his home on Rockingham. Now, at about that same time, 6:30 to 7 p.m., Nicole was arriving at the Mezzaluna with her party. That was all of her family and Sydney and Justin. Now back at Rockingham, Mr. Simpson spoke to Cato. He discussed a little bit the recital, what he wanted to tell him about it, and he mentioned to him that Nicole was wearing a tight dress, and he wondered how she'd look in that tight dress when she got to be older. During the course of that day, he also told Cato that he and Nicole were through. It's important to remember that the defendant would make statements sounding like he was cavalier about it, but the truth that we learned from the inside is that he was not at all cavalier about losing Nicole. Now, while the defendant is talking to Cato on Rockingham, Nicole and her party arrived at the Mezzaluna for dinner to celebrate Sydney's recital. Ron Goldman was a waiter at the Mezzaluna. He didn't wait on her table that night, but he was working there that night. Nicole was wearing a black halter dress and a black blazer. She left the restaurant with her family at approximately 8:30 p.m. Now, between 8:30 and 9 p.m., Cato was back in his room, and the defendant came out to his room to ask him for some change. The defendant was set to take a flight out that night to Chicago, an 11:45 red-eye. He indicated to Cato that he only had $100 bills and he needed smaller change for the sky cap. He asked Cato if he had that smaller change, and Cato said he did. He then told Cato that he was going to go out and get something to eat. Cato asked if he could come along. The defendant said, okay. They then left, and they went out to the driveway. The defendant drove to McDonald's in his black Bentley. They got some burgers, and as he drove back, the defendant ate his food while he was driving. Cato did not. They got back to 360 Rockingham, and the defendant parked his Bentley in the driveway in the same position in which it was found by the police in the early morning hours of June the 13th. When Cato got out of the car, it was 9:30 to 9:35 at the latest. And when he got out of the car, we last saw the defendant standing near the Bentley. Cato walked through the driveway, through the side yard, and back to his room. As soon as he got back to his room, he made a call to his friend in San Diego at 9:37. So we know that the defendant got home between 9:30 to 9:35 at the very latest, based on the timing of the phone call that Cato placed to his friend in San Diego. When Cato left the defendant standing at the Bentley at 9:35, he did not see the defendant again until after 11 p.m. Now, what I'm about to describe to you is a series of events that proves that the murders occurred between 9:35 and 10:45 on the night of June the 12th, and that during that time, the defendant's whereabouts are unaccounted for. At 9:37, Juditha Brown, that is Nicole's mother, called the Mezzaluna to see if they had found her prescription glasses that she thought she had left there at dinner that night. Karen Crawford, the bar manager for Mezzaluna, took that call and then went to look for the glasses. She found them out in the gutter near where the family had gotten out of their car to come into the restaurant. She brought them back into the restaurant, told Juditha that she had found them. Juditha asked her to keep the glasses there. So Ms. Crawford put them into an envelope marked Nicole Simpson prescription glasses. We'll show you photographs of that envelope today. Now, Juditha called Nicole at 9:40 p.m. and told her that the glasses had been found and were being kept at the Mezzaluna at 9:40 p.m. And that was the last time Juditha ever spoke to her daughter, Nicole. A few minutes later, Ms. Crawford received a call from Nicole, and they spoke. Ms. Crawford then called Ron Goldman over to the phone. Ron Goldman spoke to Nicole for a few minutes, and when he was done and he hung up, Ms. Crawford gave him the glasses, and he took the envelope containing those glasses. Shortly thereafter, at approximately 9:50 p.m., Ron Goldman left the restaurant, still dressed in his waiter's uniform, the white dress shirt, the black pants, and the black shoes. And his friends at the restaurant never again saw him alive.
Which graphic is this?
This is a view of the alley.
All right, what item, what exhibit number?
I'm sorry.
What exhibit number, just for the record, so we can demonstrate?
Oh, I'm sorry. Number? P1. At approximately 10:15 p.m., Pablo Fenves, who lived diagonally across the alley behind Nicole's condominium, heard a dog begin to bark. The area you see here in the photograph, and I'm trying to designate it with the red light, this is alley behind her house, behind Nicole's house at 875 South Bundy. This Jeep that you see here is her Jeep. Pablo Fenves, whom I've just described, lived in the area where you see the police car. The lights that you see here on the balcony indicate where Nicole lived. That's her condominium. This is a rear view, again, of Nicole's, the rear of Nicole's condominium. That's her Jeep. That's her garage that I'm indicating. And this is the balcony area I've indicated before, and there's the upstairs area. This is P2.
Thank you.
This garage and these living quarters here belong to another family. As I indicated before, it's a duplex. So at 10:15, Pablo Fenves heard a dog bark. He remembered it clearly because the bark was like a plaintive, insistent wail. It was like nothing he'd ever heard before. Although he'd heard dogs barking in the neighborhood often, other dogs lived in that neighborhood. This was different. This bark sounded to him like a dog in trouble. At 11 p.m., when Pablo Fenves went to bed, the dog was still barking. He went over to his bedroom shutters and opened them to look out in the direction that the barking seemed to be coming from. And he looked in the direction of Nicole's condominium, which is the direction it seemed to be coming from. And he noticed that there were lights on in the upper floor of her condo. When he fell asleep, shortly after 11 o'clock, the dog was still barking. The evidence will show that this dog, wailing and barking so insistently, was Nicole's white Akita, Cato. Another neighbor, Steve Schwab, left to take his dog for a walk at approximately 10:30. At about 10:55, when he got to the corner of Dorothy and Bundy, which is right on the corner of Nicole's, where Nicole lived, maybe one house down, he saw Cato the dog walking alone. The dog was acting very agitated, seemed to be barking at the house on the corner of Dorothy and Bundy. He couldn't tell which one. And he noticed that the dog had an expensive collar. When he checked it further, looking for tags, he noticed that there was blood on the paws and on the legs of the dog. Although at that time he saw no injury, he assumed there must have been a cut on the paw to cause all that blood. As he continued to walk, the dog began to follow him, but it behaved in a very strange manner, because at the walkway to every house that they passed, the dog would stop and bark insistently. When Steve got home at approximately 11:05, he and his wife discussed what to do with this dog. They sat outside, gave it some water because it seemed very dehydrated, and decided to try and get it to lead them to its owner's home. So they took it out and they started to walk back, but as they neared Bundy, the dog resisted. The dog pulled back, and they couldn't get it to go any farther. So they took the dog back to the courtyard of their apartment building. Now, in that courtyard, there was more light, and they were able to see more clearly that there was no injury on the dog, but that its paws and its legs were clearly bloody. Now, Steve Schwab later gave that dog to another neighbor in his apartment building, Sukru Bostepi. You'll see them testify in this courtroom. And Sukru Bostepi agreed to take care of the dog for the night. But again, the dog was acting very agitated with Sukru Bostepi. He tried to take him inside the apartment, and he was sniffing and scratching and trying to get out. So he tried to do the same thing that Steve did. And he took the dog out for a walk, hoping it would lead him back to the owner's home. As they went south on Bundy, the dog started pulling harder and harder until they got to the location of 875 South Bundy. And there at the pathway leading up to that home, the dog stopped. And the dog looked up the pathway. And that made Sukru look up the pathway. And there he saw a sight that he'll never forget. He saw the body of Nicole Brown lying at the foot of the steps in a pool of blood. Now I'm going to backtrack for a moment and talk about Rockingham. I last mentioned Cato at 9:37. He was on the phone to his friend in San Diego. He was on that phone for 7 minutes. That call ended at 9:44, at which point, after trying to use the typewriter in that office I showed you before, which is right next to his guest unit. This be the room right here. He called his friend Rachel Ferreira.
Once you finish with that,
It goes into, it's kind of better to break here if that's all right with the colleagues.
all right. All right, ladies and gentlemen, we're going to take our recess for the lunch hour. Ms. Clark, could you take the poster down, please?
Yes.
Thank you. All right, ladies and gentlemen, we're going to take our recess for the lunch hour. Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions about the case, talk to anybody about the case, or allow anybody to talk to you about it. And we will see you back here at 1:30. All right, have a nice lunch. All right. All right, good afternoon, counsel. Is there anything we need to address before we invite the jurors to rejoin us? Mr. Cochran?
Thank you very kindly, Your Honor, and I'll be very brief. This morning, Your Honor, I have received several calls regarding the witness, Rosa Lopez, and at noon, I spoke with her personally. She indicates she's being besieged by individuals who are trying to either interview her. The press is outside of her house. She can't get out of her driveway or her where she works. She's very, very afraid that in these harsh economic times that she may lose her job. Her lawyer, Carl Jones, has written a letter asking that should the people want to interview her, he'll arrange it and not to try to come on her job. She is works as a housekeeper, and I don't know what the court can do about the press, but she was really exasperated when I talked to her, and perhaps the court can appeal to the good side and the press and ask them if they would give her some privacy. She's very, very concerned about herself and her family. She feels it's unfair. I thought I should bring this to your Honor's Court because I got a call here, and several calls here in court.
All right. Mr. Darden, you have some response or comment on that?
Yes, Your Honor, thank you. And I appreciate Mr. Cochran's comments. I would just like to indicate that we haven't been part of the harassment. We haven't attempted to contact Ms. Lopez, as Mr. Douglas alluded to yesterday. And I would join in Mr. Cochran's request that this witness, as other witnesses in the case, not be harassed by the media, by the public. Leave these people alone. It's not their fault that they happen to be witnesses in the case of People versus Simpson. And we will contact Mr. Jones at the proper time and before we attempt to interview Ms. Lopez.
All right.
We join, we can agree on something, Your Honor, and we welcome your suggestion to the press if you have one.
I think it goes without saying. All right. Thank you, Counselor.
Where's the jury coming in?
Yes.
We're busy somewhat.
Yeah.
If I could just step outside for 1 moment.
Sure. I'm sorry? Briefly,
Well, for the same purpose, because we got somebody else out.
who are we missing?
Our technical support.
All right. Is Mr. Harris here? Mr. Harris? What's the warm-up time on the Elmo? All right, Ms. Clark, are you ready to proceed? Are we ready to proceed? All right, Deputy Magnero. All right, thank you, counsel. Be seated. Ladies and gentlemen, thank you. Back on the record in the Simpson matter, Mr. Simpson is again present before the court with his counsel. People are represented, and we have all the members of our jury panel again present with us. Ms. Clark, do you wish to continue your opening statement?
Thank you.
All right.
Good afternoon, everyone. I forgot to introduce a very important member of our team, and I sincerely apologize for that. Jonathan Fairlow. He's a new member of our office, and he does all of the technical work that you're seeing here. I wouldn't have a clue how to operate these things without him. I'm in serious trouble. I hope you all had a very good lunch. Let me remind you of where we left off so that we can pick up from there. We were talking about the timing, and I was discussing with you that Cato had last seen the defendant at 9:35 at Rockingham, and that an hour and 10 minutes, and that it was after 11 before he saw him again. So he saw the defendant at 9:35, did not see him again until after 11, and during that period of time, the defendant's whereabouts are unaccounted for. Now, last I spoke to you, Cato was on the phone with his girlfriend, Rachel Ferreira. At that time, At that same time that he was on the telephone, and this was approximately 10 to 10:15, Alan Park, a limousine driver, was on his way to Rockingham to pick up the defendant to take him to the airport, where he would take his flight at 11:45 to Chicago. Now, although his instructions were to arrive at Rockingham at 10:45, he hadn't been in the Brentwood area before, and he didn't want to be late. So he left early, and he arrived at Rockingham at 10:25. Now, I'm going to use the diagram again. When Alan Park pulled up on Ashford Street, he parked across the street from the defendant's residence, got out of his car, sat behind it on the curb, and had a cigarette. He got back in his car at about 10:30, sat in his car for a few minutes listening to the radio, and at 10:35, he decided that he would go and look at the Rockingham gate to see if that drive-in would be easier for him than the Ashford Street gate. What I should tell you right here is that he was driving a stretch limousine, and that has a very hard time making tight curves. He wanted to be able to pull up in front of the front door to an area that would be easy to load the baggage. And so he wanted to see if the Rockingham entrance would be more easy for him than the Ashford Street address. So he decided to pull down to Rockingham. He pulled the limousine down to Rockingham, all the way down to the point where the driver's side window would be parallel with the Rockingham gate, so he could look inside. Now, in doing that, he had to pass right by the curb area just north of the Rockingham gate. And what he noticed when he pulled to that area that was right in his field of view is that there was no car parked there. No white Ford Bronco. And it was 10:39. That's very important. We'll come back to that again. He looked down the driveway, and he saw that that looked like a tighter turn even than Ashford. So he backed the limousine up Rockingham Avenue and made a left turn onto the Ashford Street and pulled right up to the Ashford gate. When I say he pulled right up to the Ashford gate, on this photograph you see the Ashford gate of the defendant's residence. He actually had the grill of the car almost touching the gate, facing inward toward it. I thought we gave the court.
It's P 29. Thank you.
Your Honor, so the court won't have to inquire after every photograph. We can get in a list to the court for each and every one with a
Well, I think you should make the record, counsel. You should tell us which this is. Because the clerk can't see, the clerk has the list. She can't see directly the video. So you need to tell me which video we're using, which graphic we're using.
Very well, Your Honor. I'll ask that Jonathan Fairlow be allowed to.
Fine.
Thank you, Your Honor. Now, when Alan Park pulled back to the Ashford gate, parking up against it, facing into the driveway, he looked at his watch, and it was 10:40 p.m. At that point, he decided to go and ring the buzzer. I wanted to show you something else on there so you'll know what I'm talking about when I say ring the buzzer. I'm guessing with this red light, you can see right here, that's the call box, where you'd be pressing the buzzer. And it rings inside the house. The person inside can then press a button to open the gate. At 10:40, he began to ring the buzzer. He could hear it sound, but there was no answer. There were lights on in the upstairs, one light on upstairs. There were no lights on downstairs. It seemed to him like no one was home. and he was a little worried about that, so he decided to page his boss and find out if perhaps the plans had changed. At 10:43, he paged his boss. He was then worried that perhaps the page didn't go through, so at 10:49, he called his boss at home, but there was no answer. He then got out and pushed the buzzer at the Ashford gate a few more times. Still got no answer. Now, during this period of time, Cato is still in his room on the phone with his girlfriend, Rachel. Now, what I haven't explained to you yet, this area here shown, this is the southern border of the defendant's property. This is a walkway here, but it's not like a sidewalk. It's very narrow and it's very dark. Just a few feet wide, it's covered with leaves. It has the shrubbery that's indicated here. It's actually from the neighbor's yard. And there's a chain link fence, the shrubbery's right up against it. It overhangs the walk to make it very dark. Here you can see what's indicated as an air conditioner. I don't know if you can all read it, but that's what's written here, this little black box here. This air conditioner actually hangs over the walkway quite a bit. It's an air conditioner that is set into Cato's wall. So you can see the air conditioner on the inside, and then it hangs outside the wall, outside the house, over that walkway. So that this wall of Cato's room faces onto the south walkway. There's no entry or exit there. He can't go out that way. If he wants to exit his room, he has to exit through the doors that are right here. They're like shuttered doors, like shutters, door-like shutters. And he goes out through those shuttered doors to the pool area, and that's how he exits. So on that night, he's on the phone with his girlfriend, Rachel. How about the photograph? Okay, what's indicated here, P what? P what?
P4.
What's indicated here is the area I've just described to you. You see the shrubbery from the neighbor's yard and the chain link fence. And this is the air conditioner right here that I'm circling. That air conditioner is for Cato's room. It's set into his wall. This is the walkway. You can see how dark and narrow it is. This is a shot taken during the daytime. At 10:45, Cato was talking to his girlfriend Rachel when suddenly he heard on the wall where the air conditioner was 3 loud thumps. The thumps were so loud that a picture on that wall actually moved. Cato was alarmed. He asked Rachel, "Have we had an earthquake?" When she said she hadn't felt any, he became even more alarmed. And then he wondered if there might be a prowler, somebody trying to break in, because if it wasn't an earthquake, that's what it had to be. He was worried about the sounds he had heard. He was worried about those thumping noises. And so he decided that even though he was afraid, and it was late at night and it was dark, he should go and see what the cause of those noises might be. A few minutes later, he hung up with Rachel and went out of his room to go and look.
P6.
This is a picture of Cato's room. Right up here, where I'm indicating, that's the air conditioner in the wall. The part of the wall that you can't see in this photograph, which would be actually over here, the opposite side of the bed, is where the picture was hanging that moved when the thumps were made. And now the shuttered doors I referred to, you can see them here at the left edge of this photograph. See them better here. This is taken from the head of the bed facing outward. These are the shuttered doors that lead out to the pool area.
P5.
He walked out of those shuttered doors and out through the pool area, coming out onto the side lawn that borders Ashford Street. When he came out to that side yard, He saw the limousine that was pulled up to the Ashford gate, but he figured that the defendant had already made contact with him, was about to let him in anyway, and didn't pay any further attention because he was very distracted by what the cause of those noises might be. Now, with him, he had a little dim flashlight that he was going to use to try and see what was going on back there in the dark. In the meantime, just before Cato came out onto the side yard, Alan Park was standing at the Ashford gate ringing the buzzer, still getting no answer. Finally, he heard the car phone ringing inside his car, and it was 10:52. He had still received no answer to the buzzing at the Ashford gate. Got back into the car and spoke to his boss, telling his boss, "I don't think anybody's home. What shall I do?" His boss told him to wait a little longer, and when he'd been speaking to his boss for 3 minutes, he saw Cato coming out the side yard with his little flashlight. Almost simultaneously with seeing Cato in the side yard, he saw a person 6 foot tall, 200 pounds, wearing all dark clothing, African American, walk quickly up the driveway and into the front door entrance. Immediately, as that person entered the house, the downstairs lights went on. Alan Park hung up the phone and walked over to the Ashford gate and buzzed again. This time, he got an answer. And the defendant said, a voice that Alan could recognize as the defendant's. The defendant said, "Sorry, I overslept. I just got out of the shower. I'll be down in 1 minute." Now, Cato, who was distracted by the possibility of a prowler, wasn't looking to see if anyone was coming and didn't see. And although Alan Park could not see well enough at the time the person entered the house to identify who it was, clearly that was the defendant. Now, while Alan was standing at the gate speaking to the defendant on the intercom, Cato decided to walk around to the south side of the garage, and he was going to attempt to go down that narrow walkway to see what had happened. But when he got actually back to this corner of the garage with that little dim flashlight, it was very dark and he was scared. So he decided not to, and he came back around. When he came back around, he realized that the limo driver was still outside the gate. So even though the defendant had spoken to him and said he was coming down, he did not open the gate for him. Cato had to go and open the gate. He opened the gate and he let him pull in. As soon as Alan Park pulled the limousine into the driveway, Cato, who was still very worried about the sounds, started talking to him, telling him he'd heard the thumps on his wall. His picture moved. He thought it might be a prowler, or maybe was it an earthquake? Had Alan felt an earthquake? Alan said, "No, I haven't." Cato was very nervous. But now, with Alan pulled into the driveway and inside the grounds, he felt a little safer. So Cato decided to go back to the area and try and check out the sounds and what had caused them. When he went back to the south side of the garage, he went through a first gate that basically you just lift and push against the wall. It's not a locking gate. Went up as far as a second gate, but couldn't see anything. It was still dark. The flashlight was very dim, and he decided to come back. He was still too afraid to go back there by himself. Cato came back out around the garage, and when he came out, he saw that the defendant had come out of the house by that time. Defendant was now wearing a light blue denim shirt and light blue denim jeans. As he came out, Cato also noticed that there was a small dark bag placed near where the Bentley was parked. Remember I told you the defendant parked his Bentley this way, facing out towards Rockingham. He could see that there was a small dark bag on the grass near that Bentley. It was Alan, Park, and Cato who were loading all of the bags into the limousine. And while they were loading the bags into the limousine, Cato spoke again of the thumps that he had heard, and being worried that it was a prowler, thinking it might have been an earthquake, hoping, I guess, it was an earthquake. So he asked the defendant for a better flashlight so he could go around to the back area and check out the source of those sounds again. He and the defendant then walked into the house very briefly, but then the defendant said, "Oh, it's late, I gotta go." Came back out. While they were loading the bags, Cato offered to go and get that small dark bag on the grass and put it in the car for the defendant. Unlike any of the other bags, the defendant said, No, I'll go get it. He went and got the bag, the defendant got the bag and put it into the car. Now, the defendant did not give Cato a better flashlight, and when he left, although Cato seemed very concerned about the thumbs, the defendant seemed relatively unconcerned. He got into the limousine and they left for the airport at approximately 11:15. Now let me back up for a minute. Just before he left, the defendant asked Cato to set the alarm. Cato said he didn't want to do that. He'd never set the alarm before. He didn't know the code. He felt very uncomfortable with the responsibility. Told the defendant, no, I really don't want to do that. The defendant then left. They left out the Rockingham gate at 11:15. Cato went back to his room to call back his girlfriend, Rachel Ferreira, as he'd promised to do. On the way to the airport, the defendant repeatedly complained of being hot. Alan Park could see that he was sweating, and he rolled down the windows and turned on the air conditioner. The temperature that night was 63 degrees. During that drive to the airport, Alan could see that the defendant was moving around with his bags in the passenger compartment, although he couldn't see exactly what he was doing. They arrived at the airport at 11:30, and that small dark bag that the defendant insisted on putting in the car himself was never seen again after the defendant left for Chicago. Now, during the time the defendant was driving to the airport, Cato was on the phone again with his girlfriend, Rachel. During that phone call, there was a call waiting interruption. Call was interrupted by the defendant. The defendant told him, "I need you to set the alarm. I forgot to set the alarm." He had to give Cato the security code and tell him where to go and set the alarm. There was a keypad outside the front entrance, front door. Now, in the 6 months that Cato had been living there, the defendant had never asked him to set the alarm before, had never had to give him the security code before. This was the very first time that had ever happened. Now, at this point, we know the following. I'll talk to you about the timing again. Cato last saw the defendant at 9:35 when he was standing by that black Bentley after they'd come back from McDonald's. 40 minutes later, at 10:15, we hear Nicole's dog barking, that loud, insistent bark that went on and on and on. And it would be safe to assume that it was very shortly within that period of time that the murders occurred. When Alan Park drove over to Rockingham and saw that the defendant's Bronco was not there at the Rockingham gate, it was 10:39. And so we know that the defendant had not yet returned home. The drive to between Rockingham and Bundy was timed, taking a normal rate of speed between the hours of 9:30 and 10:30 at night. It took approximately 6 minutes. Just so you can see the relationship of the two locations. Here's Nicole's condominium, 875 South Bundy. Here's the defendant's residence, 360 North Rockingham.
All right, for the record, this is
Brentwood?
be a blow-up of the Thomas Brothers map.
Yes, that is Redwood area.
All right.
So at 9:35, last sight of the defendant. 40 minutes later, at 10:15, the dog is barking. Nicole's dog is barking. At 10:45, half an hour later, we hear the thumps on the wall. This leaves us between 9:35 and 10:45 for the defendant to drive from Rockingham to Bundy and back, a total of 12 minutes, which leaves him a full hour to commit the murders. Now let's go back to Nicole's home on 875 South Bundy. Now I'm going to show you what Sukru Bastepi saw when Nicole's dog took him to 875 South Bundy.
P7.
This is the view from the walkway. This is from the sidewalk area. At the end of the walkway, at the foot of the steps, you see the body of Nicole. She's wearing the black dress that she wore at the Mezzaluna that night. Officers Risky and Terrazas were the first officers to arrive at the scene. They got there at 12:13. That's 12:13 a.m., shortly after midnight. They immediately contacted Mr. Bastepi and his wife, who pointed to where they had seen Nicole. Next. What you see here is what officers Risky and Terrazas saw when they arrived at the scene. You can see here the paw prints
P8.
of a dog. Officer Risky will describe to you what it was he saw when he got there. They were the same paw prints, no shoe prints, only dog prints up and down this walkway. In order not to disturb the blood or any of the evidence, Officer Risky and Terrazas walked up the side where you see the bushes next to the walkway.
P10.
They walked alongside. It would be to the left side of the walkway.
Give me just a moment before you bring up the next one to let me know and let me know what it is. Because I indicated to you, I do not want to let out a video feed of certain items. Thank you.
Officer Risky went all the way up to the end of the walkway in the bushes to a point where he was able to see at that point that it was not just Nicole, but also Ron. Your Honor? This one.
P11.
Thank you. You see here Ron Goldman, as he was found by officers Risky and Terrazas. Now, what you're not going to be able to see in these photographs, ladies and gentlemen, is the fact that Nicole Brown's throat was hideously slashed. And you'll be able to see, and the evidence will show, that her murder took very little time to accomplish. The same goes for Ron Goldman. As a matter of fact, what you will be able to see in this case, that I'll describe to you now, is the area in which he was confronted. The area in which he was suddenly attacked by this defendant was very small. He was literally backed into a cage where he had nowhere to run. And that is how his murder was accomplished in a very short amount of time. You can see the area he's in right there. What you can't tell from these photographs is how small, how narrow this area really is. It's very small. He's bordered on one side by the rungs that you can see by the fence, and by the other at his feet. Yet another fence. It's literally backed into a corner. Now, so you can see the relationship and how close Nicole and Ron actually were. I have a diagram.
Can you take a picture now? You need a picture?
Yes. What this board shows you, and this is a board you want to call 875 South Fundy Drive, depicting envelope, hat, glove, and both of the victims.
Thank you, Your Honor. Your Honor, we're going to move to the screen and it's going to be crime scene photograph. Thank you.
P12.
All right, this is a view looking from up to down. We did warn you, ladies and gentlemen, that this was a case that was going to have photographs that would be very, very hard to look at. We have to show you the evidence, and I apologize for the graphic nature of them, but this is the crime that we're here to examine. Looking down
the steps. What the officer is pointing to is the ski cap and the glove that I've just shown you in the photographs. You can see it now in relation to Nicole. At the top of the photograph, you can just see the boot of Ron Goldman, and you can see the envelope in between them. That is the scene as it was found by Officers Risky and Terraza.
P13.
There's a close-up. You can see now underneath the plant. It was harder to see before from a distance. The glove and the ski cap. What you can also see here is the bloody shoe print. We'll be showing you more of those.
All right, Ms. Clark, I'm going to release this one video.
Okay.
P14.
This is a little bit closer shot to let you see how clearly you see the bloody shoe print at the scene, right at the, right near the ski cap and the glove. And you can see how on a dark night, when it is dark there, the ski cap and the glove would be hidden by the plant, be difficult to find. And under pressured and hurried situation, you're not going to have a lot of time to look for them. Upon seeing that what you've just seen here, you ladies and gentlemen, Officer Risky went and notified his supervisor, who arrived at 12:30. A crime scene was immediately set up. Yellow tape was placed in front of the residence and behind the residence in order to make sure that no one would walk in and disturb any of the evidence. After the arrival of his supervisor, Officer Risky entered the condominium. Now, what I should tell you is that when he came to the scene, he found the body of Nicole. He could see the front door of the condo, and it was standing wide open. So she had just come outside when she was attacked. He went inside, thinking that there might be a suspect inside, and looked all through the house. Not only did he not find a suspect, but he found no evidence of ransacking, no evidence of forced entry, no evidence of a struggle, nothing that would indicate this was related in any way to a burglary. When he got upstairs in that condo, he found the two children, Justin and Sydney, asleep in their beds. They were taken quickly out of the condo, out through the rear, to avoid the hideous sight in front of their house. Now, what Officer Risky saw, he had gone inside to clear the house. He came out the front door and he looked down the walk. And I'd like to show you now what he saw on that walkway.
P.
Okay, Your Honor, this is... Can you kill this one?
Okay, I'm going to turn it off until I see something.
Thank you, Your Honor.
P15.
What I'm showing you here is a shoe print, again. Right here, heel print, a bloody heel print, and another one here. Next.
P16.
Again, bloody shoe prints. You can see one set of bloody shoe prints as they go down the walkway.
All right, I'm releasing this one.
Those bloody shoe prints, that one set of bloody shoe prints continues all the way back towards the rear alley area where there's the driveway. Remember I showed you earlier on that there was a driveway area behind the condominium where her Jeep was parked? These bloody shoe prints are all in the same direction, leaving the bodies of Ron and Nicole, going towards the back area.
P17.
And you can see them here again in a perspective shot. I'm circling with the red pen. About halfway down the walkway, they start to fade out as the blood is picked up by the sidewalk. What Officer Risky also saw were that there were blood drops just to the left of those bloody shoe prints. So next to that single set of bloody shoe prints leaving the scene, you had blood drops to the left of them.
P18.
These markers here indicate where there were blood drops found. And close up.
P19.
It's a close-up of 112 that you saw farther in the distance, the blood drop.
P18 again.
That gives you the perspective. Now I can show you what I was talking about. Here's a bloody shoe print. To the left, blood drop. I'll farther, see this one I'm circling here, close up,
P21,
another blood drop. You can see that it is to the left again of a bloody shoe print. You can see that's a heel you're looking at there.
P22,
Again, this is showing you another blood drop that was found going down the stairs. I should explain to you, ladies and gentlemen, that the walkway going from the front of the house to the rear has many stairs going up and down. See, there are landings going up and down. See a lot of stairs on this pathway. And on these stairs as well, I'm circling here. That's a blood drop. There were also bloody shoe prints seen here. I think you can even see this one I'm circling with the pen right now.
P23,
And that's close up, the one on the stairs. Blood drop.
P24,
Again, now this is at the rear gate of the condo. This tag shows another blood drop that was found. Close up,
P25,
and there it is. And now the blood drops continued out to the driveway area.
P26,
These markers show close up.
P27,
You see here the blood drop on the driveway. Now, the shoe prints that you saw were determined to have been made by a size 12 shoe. The defendant wears a size 12. The blood drops to the left of the bloody shoe prints. When the defendant returned home from Chicago, he was found to have had a cut to the middle finger of his left hand.
P35,
The case was assigned to the Robbery Homicide Division. Detectives Philip Van Adder and Tom Lang, the investigating officers assigned to handle the case. They arrived at the scene just after 4 a.m., and they viewed the crime scene and the evidence as I've just described it to you. They found the same things that Officer Risky found. Given the fact that there were 2 young children being held at the station pending some adult who could take charge of them, they determined that they would go and make notification to the defendant. They then proceeded to the defendant's house. Now, they got to the defendant's house at approximately 5 a.m. At that time, they started to ring the Ashford gate, and they buzzed, but they got no answer. Now, at that point, they could see there were lights on in the house, there were cars in the driveway, but no one was answering. They eventually got the defendant's home phone number, called it repeatedly, but again, they got no answer. Then the detective saw the white Ford Bronco parked at the Rockingham gate.
P30,
This is the position in which the Bronco was found, just to the north of the Rockingham gate, and that's what you're looking at here. This area here is the Rockingham gate entrance to the defendant's home. This is the location that Alan Park drove by earlier that night at 10:39 and saw that there was no Bronco there at that time.
P31,
The detectives noticed that there was a small spot of blood near the driver's handle of that door. The criminalist is pointing to it here. That's Dennis Fung.
P32,
That's a close-up. You can see how small that spot of blood is.
P33,
This is taken from the rear of the vehicle.
P34,
Inside the vehicle, they saw in the rear cargo area, they were able to see a package that was addressed to Orenthal Productions. Knowing that that was the defendant's first name, they realized that was probably his car. After all they had seen, and failing to be able to get any answer at the defendant's home, they became alarmed and they decided they would enter the property to see if they could locate someone or find perhaps another victim. When they went in, they went first to Cato's room. They knocked on his door and they asked him if there was someone there who could assist them. He directed them to Arnell, who was right next door. Cato told the detectives about the loud thumps that he had heard against the south wall of his residence that night, and about being worried about the source of those noises. After he told them about those noises, indicating that it was on the south wall and it seemed to come from the area of his air conditioner, the detectives went out to look to see what could have caused those noises.
P36.
And this is where they went, the same area that Cato had walked to earlier but never gotten up to because he was too afraid, the area of the air conditioner. As they approached this area, it was very dark. They were unable to see anything until they got closer.
P37. P38.
And there's the glove where it was found, in the very same location in which it was found that night, right next to the air conditioner on that narrow path. When they saw that glove, they realized that it looked like the mate to the glove that you also already saw at the Bundy scene underneath the plant at the foot of the body of Ron Goldman. They then realized that perhaps they needed to secure the residence, and Detective Van Adder then walked out of this pathway and out onto the driveway.
P40.
When he walked out onto the driveway, what Detective Van Adder saw, now that it was becoming light, it was at least 6 o'clock in the morning at that point, were blood drops on the driveway that led from the Bronco and all the way into the house.
P41.
And close up,
P42.
and there's the blood drop, one of the blood drops that was seen. On the-
P43.
This was inside the house. This is right inside the front door in the foyer area. There were a series of 3 blood drops here, close up.
P44.
You can see them here. I'm circling them. Having seen all of this, the detectives then realized that this was not just an occasion to make notification, that in fact they had uncovered evidence that indicated that the defendant had committed these murders. They secured the home and prepared to conduct a search. Criminalist Dennis Fung arrived at Rockingham at about 7 a.m., where he began to test all of the blood drops they had found. He tested the Bronco, and then he tested the drops on the driveway, determined that the drops on the driveway were indeed blood. Then he went to test the glove and found that it too contained blood. A search of the house, inside the house, revealed, among other things, a pair of rumpled socks at the foot of the defendant's bed in his bedroom.
P45.
You see there the socks that I just spoke of. This is exactly where they were found, in that condition.
P46.
Close up. Those socks were collected, along with many other items, and submitted for analysis. Now, the defendant's Bronco that you earlier saw in Rockingham proved to be locked. They couldn't find any keys for it, they couldn't get into it, so it was towed in a locked condition to the print shed, which is an area where the police keep large items that need to be fingerprinted, where they can keep it locked up. They towed it to the print shed and did not open it until the 14th, when they opened it by use of a Slim Jim. You'll probably hear some discussion of things that occurred with that Bronco after the 15th, and they may be interesting, but they have nothing to do with the evidence that was recovered on the 14th. And a search for blood was conducted of that Bronco on June the 14th. Those items were recovered, the blood was collected, and it was analyzed And those items that we'll be talking about today that were analyzed were recovered from the Bronco on June the 14th. Now, all of the items I've just shown you were collected and submitted for examination and analysis, and what you have here is a trail of blood from Bundy Drive to Rockingham Avenue and into the defendant's very bedroom, linked by the defendant's white Ford Bronco. I'm not going to go into the details right now with you, ladies and gentlemen, about the manner in which evidence was collected or the manner in which it was all analyzed. We have experts for that. But I do want to make some general comments in order to point out a few things right now, just to dispel any misconceptions anyone might have about evidence collection and analysis. First of all, collecting blood stains is a very simple thing. You or I could do it. And I tell you this because I'm not that good mechanically or scientifically, but even I could do it. What you do is you take a very small square of cotton and you put distilled water on it and you soak up the stain. There's no magic. Anyone can do it. It's just like you would go and soak up a spill in your kitchen. Not very different. Now, many laboratories or many police agencies use lab technicians for that. You know, people that don't have a bachelor's of science or any particular degree in criminalistics or forensics. Forensics is a science of crime scene analysis and investigation. Many of them don't use anyone with a degree in that, but LAPD does. LAPD uses criminalists who are people that have Bachelor of Science degrees in forensic science, the science of crime scene analysis. So they actually use people that are overqualified for the job. A likely issue in this case will be the testimony of the coroner. Now, I know that we've all seen, some of us have seen anyway, Quincy, seen Jack Klugman on television. He goes out to investigate the crime and he finds out who did it. In the general course of things, although there is a coroner's investigator, that investigator is just responsible for collecting the body from the scene and getting it to the coroner's office intact. What the coroner does is the coroner looks at the body to determine cause of death. Ladies and gentlemen, I can guarantee you one thing in this trial: there will be no dispute as to cause of death. No one will argue about what the cause of death was for Ron Goldman and Nicole Brown. The issue that will be raised is the time of death. Now, what can a coroner do for you with respect to time of death? The coroner can never really be that precise. A coroner can tell you, just based on his examination of the body, he can usually bring it down to a range of within 3 hours, between 9 and midnight, between midnight and 3. But if you want to pinpoint the time to within a minute, 10 minutes, a half hour, or even an hour or 2 hours, a coroner, solely by his examination of the body, cannot do it. We always have to, and that's true in any case, we always have to rely on the testimony of other witnesses, witnesses who will tell you when the victims made a phone call, or when they heard the victim leaving the house, or when they last saw the victim. Dogs barking, the kind of evidence I just talked to you about, is often what is used if you want to try and really pinpoint the time, because the coroner cannot pinpoint it to within minutes or even an hour, really, in any case. Now, before I get into the analysis of evidence, I'd like to talk to you a little bit about what scientists and criminalists look for nowadays when they examine the evidence. We've made tremendous strides in many areas. In general, in order to be able to solve crimes, the police have to stay at least one step ahead of the criminals. That means that they have to look for evidence in places and in ways that the criminals will not have thought of. For example, when it became known that you could match fingerprints, criminals wore gloves. When it became known that a bullet removed from the body of a victim could be matched to the gun that fired the bullet, they started to dispose of weapons, or to use weapons that could be easily disposed of other than guns. And nowadays, it's very common to find cases where no murder weapon is recovered because they're smart enough to get rid of those weapons. So not all criminals figured this out, but the smart ones did. So we look at blood, for example. We test it for DNA. We look at hair and fiber. We examine it microscopically, comparing it to the victims and to the suspects to see if we can exclude them or if it's consistent with them. Now, in particular, the value of hair and fiber is a very unique thing. The reason for that is that through your daily life, You walk around, you shed hair, you shed fiber, you pick up hair, you pick up fiber, and you're not aware of it. It goes unnoticed. It's an involuntary thing, and it happens constantly throughout the day. There's a very fancy term for this, and it's called the Locard exchange principle. You don't have to remember that, because all it really says is when you go into a place, the environment affects you, and you affect the environment. And it's just what I said. You leave hairs and fibers, you pick up hairs and fibers. So, for example, if you have a red couch, an expert can look at your clothing and find the red fibers, look at them under a microscope and compare them and say, first of all, you are near something with red fibers, and if he has access to that couch, can examine and see if they're consistent. That is, that they could have had the same source. What the value of this is that it shows contact. It shows where items of evidence might have been. It shows who might have been in a given location and who came into contact with who. Because you find hair and fibers so often in a crime scene, because the shedding goes unnoticed, this can be of very great value in solving crimes. So every crime scene and every piece of evidence has value in terms of being able to help you solve the case. Now, with respect to blood evidence, as you know, we've made enormous strides. We have advanced our ability to extract information from blood with the development of DNA testing. This allows us to be far more precise in pinpointing the possible source of a blood stain. And we can also have then the experts tell us how rare it is that you have a blood stain matched to the type of a particular person. I'm not going to go into the details of all that testing. I'm going to let the experts talk to you about that when they come in and testify. But they will. They'll come in and tell you about all of the processes, and they'll explain how rare it is to find a match between a blood spot in a place and a particular person. Now, the defense is going to speak to you at length about contamination and all the problems that could ensue in the testing, but I'll simply say this at this point. There are safeguards built into the DNA tests that you will hear about, and these safeguards will show when problems occur. This is one of the reasons why DNA testing is so reliable. And you'll see that in this case, we have many blood stains, as you've already seen, not just one. You might question it if only one of many blood stains came back to a suspect. But when one after another, after another, after another matches the same person, then you realize that the testing is accurate, that it works, and that if there was contamination, it wouldn't keep coming back to one person. It just wouldn't come back at all. And although we're talking about science, and sometimes just saying that word can make us uncomfortable, all you're going to need is common sense and logic to follow this evidence. That's all you'll need. Now, DNA testing is not only used to solve crimes, it has many other purposes as well. Some of you talked about Jurassic Park, and they used it to make dinosaurs, but there are other more common uses for it as well. For example, it is used in the amniocentesis. We talked about that in your questionnaire and when we talked to you during the voir dire process, if you recall. That's the process where you determine whether a fetus may have a genetic defect. Most of you are familiar with that, either by first or second-hand experience. And what happens in that process is that fluid is extracted from the mother's stomach, from the sac, and that's amniotic fluid. That's a fluid that the baby floats in to protect it. They analyze that fluid to see if the baby has a genetic defect. Now, that procedure has many of the same problems.
Yes, with the reporter, please.
Your Honor, while Counselor's approaching sidebar, if we could maybe take just a little stretch break, stand up, just stand up. Maybe the jury would like to do it.
All right, thank you, counsel. And ladies and gentlemen of the jury, let the court reporter, go ahead. This is going to be a long trial, as you can tell. In the event you should need to take an unscheduled comfort break, and we will take regular breaks, but if something comes up, feel free to raise your hand, because it's going to happen to me during this trial. I'm sure it'll happen to one or two of you during the trial. So if we have to take an unscheduled break, that's life in the big city. We can deal with it. Feel free to let us know. All right? We are going to take our regular breaks. You should expect about every hour and a half or so, hour and 45 minutes. We're going to take our first break this afternoon at 3 o'clock. All right. You notice I'm very time conscious. I have clocks all over my courtroom. All right, Ms. Clark, would you resume your comments, please? Thank you.
Now, the evidence will show that the amniocentesis procedure has many of the same problems that crime scene analysis does. And those problems are this. You have limitations in quantity. There's only so much you can get, right? If you go to a crime scene, you collect the evidence that you find, and you're limited by that. The same thing is true of the amniocentesis. First of all, you can't withdraw too much fluid or it will endanger the baby. Not to mention it's very uncomfortable for the mother. You're limited in quantity then in both situations. You also have a problem with a mixture. By that I mean, at a crime scene, you will often have a mixture of the victim's blood either with each other or with the defendant. And that means that they have to know how to separate them out. Who could be the source of this and what possible mixture you have. That's a very similar problem to the amniocentesis, where you might pick up cells from the mother, and then you're analyzing for the genetic makeup of the mother instead of the baby. So they have to know how to separate that out in case it happens. So you have very similar situations. Another situation that is similar to crime scene analysis is identification of the war dead. One of the tragic aspects of dying in a war is that sometimes we're left with nothing but body parts, and we have to be able to identify whose they are. In order to establish the identity, they will take that body part, extract the DNA, and determine if it matches to, if that goes into a parental thing. You have to take the parents, and then you can tell based on what the parents' makeup is, whether this was their child. That's one way of doing it. It's called paternity match. DNA testing can do that. Now, obviously, the body parts, tissues, or organs that are found in war dead are found out in jungles, in deserts. They're found in terrible places where there's going to be a lot of deterioration. And it's difficult, the same way as in a crime scene, because in a crime scene, it's messy and dirty out there. It's going to be in a street, a sidewalk, a house, a car. That's not a laboratory situation. Well, it's the same thing with the war dead. You have kind of unfavorable conditions that are going to deteriorate a sample very rapidly. And so you have a similar problem with non-criminal crime scene uses as you do with crime scene uses. And yet DNA has been very successful in identifying the war dead. Another way that DNA has been used that is not in crime scene analysis is in identifying old remains. By that I mean skeletons. They can extract the DNA from skeletons to determine the identity of the people that once those skeletons were. And they did that recently to identify the Russian royal family that lived back in 1917. So you can see that the DNA testing procedures is a very powerful tool that is useful in many, many ways, not just in crime scene analysis, but in medical diagnosis and in identifications that are necessary in other areas. Now, there are a couple of approaches to DNA testing that can be taken. The first one, you're going to hear these terms a lot, so I'm going to start you today, is RFLP. That stands for Restriction Fragment Length Polymorphism. And that's, all you have to know is RFLP for now. The experts will explain everything to you at the appropriate time. That is a very powerful tool used to pinpoint the identity of the person who left blood or hair or fiber, or excuse me, blood or hair or bodily fluid in an area. Very powerful tool. Another DNA test, not quite as powerful, but still more powerful than we used to have, is called PCR testing, polymerase chain reaction. In that form of testing, you can take much smaller bits of DNA and amplify them. That is, actually, you just multiply them. It's like Xeroxing. And you make it large enough so that you can test it. And that's been very, very powerful tool as well in analyzing and determining the source of a stain or bodily fluid that you find at a crime scene. Regardless of the method used, whether it's RFLP or PCR, they're both DNA testing. And the tests are really tests of exclusion. What does that mean? That means that when you conduct these tests, the effort is to exclude. You analyze the DNA and you see, can I exclude the suspect? Can I rule him out? Is there anything here inconsistent with the suspect or the victims, depending on what you're looking at? And that's exactly what was done in this case. With every piece of evidence collected, the effort was to exclude the defendant and to exclude the victims. That was the focus, and that is the aim of DNA testing. In this case, we asked this question over and over and over again. Can the defendant be excluded? No matter how hard we tried, over and over, the samples were tested and retested and tested again. Over and over again, we asked ourselves, can the defendant be excluded? And over and over and over again, the answer was no. The defendant cannot be excluded. I would now like to briefly summarize for you all of the test results of the analysis of the evidence I've just described. And I'm going to start with the hair and fiber. Now, the hair and fiber is microscopic analysis. It is not DNA, okay? This is the comparison of hairs and fibers that were found on various items of evidence and in locations at the scene that were compared to the defendant, the victims, and various other items of evidence. It's easier to explain to you if I actually tell you the results.
P14.
The ski cap that was found at the feet of Ron Goldman was examined for hair and trace analysis, and it was found on that knit hat that there was fiber like those from the carpet of the defendant's Ford Bronco. Now stop and think. Why would there be carpet fibers like those from the defendant's Ford Bronco?
That's true.
Okay.
Just state what the evidence is. Thank you.
Also on that knit hat, we find hairs like those of the defendant. Which is what you would expect to find on a hat worn by the defendant. Your Honor, the next one.
P11.
Your Honor, before we pull that up.
I've got it.
Thank you. On the shirt of Ron Goldman, we find a head hair like that of the defendant. On the glove found at the defendant's home at Rockingham, we find hair like those of Nicole Brown, hair like those of Ron Goldman, fibers like those from the shirt of Ron Goldman, and fiber like those found in the carpet of the defendant's Ford Bronco.
P48.
This shows you the defendant's Ford Bronco. You see the tags? Those all indicate blood spots that were recovered on June the 14th. The blood stain on the panel, and that's, I'm going to try and indicate it with the red light because it's at the edge of the photograph where that tag is. That blood, as well as the blood on the, that blood on the panel matches the defendant.
P49.
The blood indicated here with the number 34 matches the defendant.
P50.
Excuse me. The blood on the panel here matches the defendant.
P51.
This blood on the console matches the defendant. The item number 31 on the console, consistent with a mixture of the defendant and Ron Goldman.
P53.
This blood stain was on the console. This was recovered later in time, after the 14th. That is consistent with a mixture of the defendant, Ron Goldman, and Nicole Brown.
P54.
The blood stain found in this area marked with the number 33 matches Nicole.
P40.
On the Rockingham blood trail, the item number 6, which is, they don't have a close-up of it, it's one of these 3 markers. We will have it better explained to you with a diagram during the trial. The blood spot number 6 matches the defendant.
P41.
This is the blood spot number 7 we showed you before, close up. Matches the defendant.
P42. P43.
Again, the blood drops that were found just inside the front entry of the defendant's home. This is blood drops number 12.
P44.
Matches the defendant.
P45.
The socks that we indicated earlier to you were found in this condition, thrown hastily at the foot of the defendant's bed in his bedroom. The blood on those socks was analyzed.
P46.
It was determined that the blood on one spot matched the defendant. The blood on another spot matched Nicole.
P19. Pardon me, P39.
The glove that was found at the south walkway of the defendant's property at Rockingham revealed blood that was consistent with a mixture of Ron Goldman, Nicole Brown, and the defendant.
P19.
These are the blood drops at the Bundy location at 875 South Bundy. This blood drop that you see here, marked with the item number 112, matches the defendant.
P21.
Matches the defendant.
P23.
Matches the defendant.
P25.
Matches the defendant.
P27.
Matches the defendant. Apart from the test results, ladies and gentlemen, the mere fact that we find blood where there should be no blood, in the defendant's car, in his house, in the driveway, and even on the socks in his very bedroom, at the foot of his bed, that trail of blood from Bundy through his own Ford Bronco and into his house in Rockingham is devastating proof of his guilt. And the results of the analysis of that blood confirms what the rest of the evidence will show. That on June the 12th, 1994, after a violent relationship in which the defendant beat her, humiliated her, and controlled her, after he took her youth, her freedom, and her self-respect, just as she tried to break free, Orenthal James Simpson took her very life in what amounted to his final and his ultimate act of control. And in that final and terrible act, Ronald Goldman, an innocent bystander, was viciously and senselessly murdered. Remember that in voir dire, we asked you if you could use your common sense and reason to fairly and to objectively evaluate this evidence as neutral, impartial judges of the facts. You all promised that you could and you would, and we believe that you will. We have every faith and belief in the fact that you will all keep that promise. But it will not be easy. You will be tested and tempted throughout this case to accept the unreasonable and be distracted by the irrelevant. The defense will talk to you about possibilities, and they'll insinuate many sinister things based on those possibilities. Possibilities of contamination, possibilities of setup, all in an effort to explain away all of the physical evidence. But possibilities alone do not equal proof. You've heard the instruction that says that all matters subject to human affairs are capable of some possible doubt. That's why the standard is reasonable doubt. And you'll hear the word reasonable more than once in the jury instructions, and you already have. Because if the proof standard was beyond all possible doubt, there could never be a conviction. There can always be a possible doubt about something. The question is whether you have a doubt that's founded in reason. So beware of the efforts to get you to accept the unreasonable, be distracted by the irrelevant, and to base your decision on speculation, on mere possibilities with no hard evidence to show that any of them really occurred. Listen carefully to all the possibilities and the hints raised by the defense and ask yourselves, is there any proof that any of these possibilities actually occurred? Listen carefully for the defense to explain how the defendant's blood got on 875 South Bundy Walkway. It's going to be up to you, ladies and gentlemen. You're going to have to be ever vigilant in acting as the judges in this case. Each one of you is a judge. Each one of you is a trier of fact. You have to examine all of the evidence very carefully, and as you do so, ask yourselves, is this reasonable? Is this logical? Does this make sense? Would I look at this evidence the same way?
Sounds like argument to me.
Look at the evidence the same way as you would for any other case. Now, winning is not what this is about. This is not a game. This is about justice and seeing that justice is done. 2 people have been brutally murdered, and the evidence consistently will point to the guilt of only one person as their murderer. Talking what the evidence will show.
Are you about to conclude?
Mm-hmm. There was no rush to judgment in this case. It was very carefully considered before it was filed. The evidence will show, ladies and gentlemen, that as of June the 15th, many DNA results had already been returned. As of June the 15th, there had already been a match between the defendant and the blood found at Bundy Drive. There had already been a match between the victims and the blood found on the glove at his house. Many things were known, and yet it was examined carefully, the entire case examined very carefully, and was not filed till 2 days after those results were obtained. My job is to seek justice. I've had cases before this one. There will be cases after it. This case is not about the lawyers, myself, Mr. Hodgman, Mr. Darden, or Mr. Cochran. We have to remember what this case is about. And justice for all. Ladies and gentlemen, if those words are to mean anything, we must all be equal in the eyes of the law, and we cannot use a sliding scale to judge guilt or innocence based on a defendant or a victim's popularity. We live in very, very strange times.
Counsel, this has all been argument for the last 5 minutes.
I'll wrap up, Your Honor.
Please.
We cannot succumb to the temptation to thwart justice and throw truth out the
Counsel,
window.
I'm going to have to stop you right here. I've warned you 3 times now.
All we're asking is that
Counsel,
I'm
I'm warning you. I've warned you 3 times now.
I'm concluding right now, Your Honor.
Please.
May I?
Please.
Thank you. All we ask is that you stay focused on what the case is about the murder of Ron Goldman and Nicole Brown. Thank you.
All right, thank you, counsel.
Thank you, Ron. Ladies and gentlemen, I want to thank you very much for your kind attention in this matter, and to thank you also, on behalf of all of us, for putting up with the rigors of sequestration. We all know it's difficult, and we appreciate all of your dedication to duty and service in this case. Thank you very much.
Thank you, Ms. Clark. All right, ladies and gentlemen, I think we will take our recess just a little bit early. Let me ask Deputy Magnier, how much time do we need? About 25 minutes?
25.
All right. We'll reconvene at 25 minutes after 3. All right, thank you.